Batch of matters are there. And I don't think that there is also one appeal. I am actually also one appeal. The state has also filed one. Before the
State has to file.
state has filed. The first one is state's appeal. The second one is my lord's appeal because his throat is permitted me to make a submission, not on merit. What has happened, these persons, these appellants, except the state, they were appointed way back in 2011 for something advertising. They have been continuing the last 15, 16 years. Yes. So now the question is, if signature has passed an order relying upon a judgment, which judgment has no appeal, that is a merit of the case. In fact, the entire case is that we have been appointed earlier than the circular which was issued in 2011. Our appointment is earlier and advertisement was earlier. So therefore, we are not covered by that circular. Now, what I suggest you, let the so far total number of appellants are filed, and they have been continuing for last 16 years. Also, know that judgment also without cause. Anyway, that is another part. Let the state take instruction. Let the judgment of the signature may be implemented so far the selection is concerned. So far, whether these 5% can be protected because they have been continuing, they have been regularized, they have got also other benefit, service benefit for the last 15 to 16 years. And the private opposite party also there.
I am for the read petitioner respondent. As the restrictions imposed by the government that came later in the month of December 2011.
Can it be given a retrospective effect?
Yes, but that is the issue. That restriction which came in 19/12/2011, whereas the advertisement was issued in the month of January and appointments were given in the month of March. So this restriction, in fact, that is also our argument in the appeal. These restrictions cannot be made applicable retrospectively so far as the private respondents for whom my learned senior is appearing. And for the writ petitioner, they had approached the Honorable Single Judge challenging their appointment that they have obtained the vocational certificates, +2 vocational certificates.
In addition to +2.
In addition to +2.
Yes.
But that
which is alternative
to apply for the employment that was put by the government in the month of 2000.
Without going to the medical,
that
is not the merit merit.
was it only circular or circular clarifying the regulation?
That is, in fact, clarifying the regulation.
That is, if regulation is clear in that regard, it is already there prior to.
Yes, prior to 83. And in pursuance to regulation,
let us see.
individual judgment has already been confirmed by the.
I am not arguing.
Let my senior has given a proposal.
We are also not on merit.
Provided the petitioner respondent got the benefit money. It is the depends upon the government to take instruction or not.
Take instruction.
But you have many vacancies. Also.
Yes, that is
that
number of vacancies.
In course of the hearing, the suggestion was mooted out by the appearing counsel.
Item number 2. Sir.
Item number 8. Basically, can you wait after I'm not
No, definitely, sir. No difficult. Other side is here. 18.
I am for the petitioner.
Okay.
But
So,
I am not objecting.
Personal.
Your Lordship put the question by providing whether
We forgot everything. The matter will be called, then we will remember everything.
Question number 21.
21.
Yes. Item number 2, sir.
Covered by my lord's government. Last occasion I have already said. There were 10 rate applications before on the civil judge. Yes.
Mr. Prabhat.
So this is the same thing. So in the same order may be passed. Brother, we have said that this is covered. It will be an order. Yes.
Item number 3.
Funding consider.
Challenges to the order rated single bills. But before I proceed to the impugned order, may just place very brief alert. An award is passed by the Micro, Small and Enterprises Facilitation Council on 10th of July 2023. That award was subject challenge. Application for setting aside was filed by the respondent under Section 34 of the Arbitration Act on 28 March 2024. About a delay of 179 days, 74 days. Then, finding that it is difficult to proceed there, they filed an application for withdrawal of that 34 application. The application was allowed to withdraw without any leave. After that, a writ application was filed before this honorable court. For the first time, raising the plea, which has never raised before the council, though they have filed a counter. One is that my registration was after the date of contract. Registration as a account.
As a registration as a
MSME.
As a
MSME.
MSME. And the second one was it's a worse contract and it is therefore it is not maintained.
Okay.
These are the two players. Now the honorable single judge, this matter was however placed before the division bench. Then it was in some other benches where the determination was not there, and ultimately it came to the assigned bench. And it was only on the very first day the honorable judge has passed a direction to directing the additional director to appear in person. He appeared through virtual mode, and the matter was closed on that day. I have filed the caveat questioning the entertainability, and entertainability I was raising. It is closed. Now, my lord, the lordship kindly come to the impugned order. The impugned order, the lordship directly and taking the lordship to page 36. There are 3 issues has been framed by the honorable single judge for consideration.
The only thing is that if there was a avenue available under Section 34, and then when the period of limitation has been provided under Section 34, which is inflexible in nature, then in that event, can a writ be approached, writ court, and then as a not rotate?
And that's exactly is my case. I have also
You are respondent.
That is your
You are respondent.
no.
You are appellant. Appellant.
He has suffered the order of the from the single bench. Now I think what are the judgments you show us that is permissible?
Mr. For IOCL, I think Mr. Srinivas Mahanti is appellant.
Who is appearing for the appellant? I think, sorry, the writ petitioner.
Yes, I'm appearing
For the writ petitioner.
Ajay will not stated. What is that? Here the honorable single judge has interpreted the contract, which is a disputed question of fact. That is not permissible. That is.
No, we are on a more basic question.
That is
That whether the writ petition is maintainable
Last question.
or intertenable when section 34 was approached and they found that it is beyond the period of limitation,
Withdraw.
inflexible time, whether that can be done. This is the first question. Are you ready with any decision on this point?
The Glasgow Smith can have.
Glaxo, yes, we know.
That's the second judgment. That is
In arbitration, I think there is a direct decision.
the same.
No, the decision. And what about the Sarguja transport? What for?
Second
That's
petition without leave.
yeah, withdrawal.
Without leave.
That
Eh,
means
without-
order 23 rule 1 concept.
Yes, ma'am. That is also debarred. And the same light in the 2023, it says that withdrawal of the suit will also bar from filing the writ application. That is the state of Odisha and Lakshmi Narayan Das.
Yes.
And the last one is your lordship's judgment that it has taken care of all the judgment that whether interpretation of a contract is possible and
That is under section 34. It cannot go beyond that. It is the arbitration, the arbitral tribunal is the last forum of interpreting the contract. That is what I believe I held.
Another just one and more aspect, my lord. They themselves in the contract, in the tender, given the benefit to the MSME. And now they are just taking a different stand. That also I'd lordship drawing your lordship attention to one minute at page 62. And this is page 62, my lord, and lordship can have that. Last condition.
Yes.
EMD must be submitted online by the Indian bidders and EMD responsible.
Yes. Yes.
So then we will accept the property. The tenderer without EMD is liable to be rejected. However, MSME, a registered agency covered under the MSMED Act, central or state PSUs and so on are exempted from submitting EMD. So this has been granted the MSME council benefit or provision attracted to that, and I have participated on the basis of that without giving EMD.
Yes.
So now they are saying that the MSME Act is not applicable because it's a vast contract. No.
Yes.
India Glycol is preferred. India Glycol is preferred.
No, yes, ma'am. India Glycol.
Paragraph 41. Indian
Paragraph 41 of the.
that is relatable to MSME.
Yes, paragraph 41 of the report.
Yes.
This is given to us without the discussion question.
Anything more?
Yeah.
Yes. Support the judgment.
Yes.
And my lords, when we withdrew the section 34, we withdrew it and we said that we're not pursuing the section 34 option. But when we filed the writ petition, and this is very important, we filed the writ petition on the premise of a lack of inherent jurisdiction.
Now question is that,
Yes.
can you not raise this particular issue under section 34? Under section 34, you can raise that issue of inherent lack of jurisdiction. If you can, then in that event, because now it has expanded,
Yes, ma'am.
the legality, perversity is also within that particular ambit of section 34.
Yes, but my lords, what we have done on behalf of Indian Oil is we have gone on inherent lack of jurisdiction, which may.
Can you go it? I'm talking about, I'm thinking in the light of Kiran Singh's judgment of 54 Supreme Court. I am aware
My lords.
that there are three kinds of a jurisdiction which the court assumes. One is the territorial jurisdiction, one is a pecuniary jurisdiction, and third one is the jurisdiction in relation to a subject matter, which is called the plenary or the inherent jurisdiction. So if other two can be waived under the Code of Civil Procedure, I believe section 21. But so far as the inherent, it is untouchable. It cannot be waived by a party. Now question is that when you can raise this point under section 34, then in that event, why? You will approach the writ court is another forum without seeking any leave and withdrawing from section 34, knowing fully well that you are out of time.
Well, that
You are beyond the outer limit.
But in this case, now my essential case is inherent lack of jurisdiction.
Can you raise it?
Yeah.
I'm just asking.
Unless my learned friend is able to show a direct judgment saying that I was precluded, I could have raised it in 34. I chose not to raise it in 34. I chose to come directly to the court on inherent jurisdiction. Now the question I ask myself, my lord, am I precluded from coming to the court in our 226, 227 petition, challenging inherent jurisdiction? Because as my lord said, the third type of jurisdiction is something that cannot be raised. Someone that doesn't have jurisdictions in the first place, that matter can be taken up at any stage.
Now,
In
the
fact,
the question is not that you cannot take that plea. The question is the choice of forum. If the forum is provided, can you jump the forum? Can you take a circuitous route of achieving a thing which you can achieve directly, but sought to be achieved in an indirect manner? That is what is troubling us.
So unless may I put it this way?
Suppose an arbitration, this is relating, anyhow, the Arbitration and Conciliation Act is somehow imbibed by virtue of the statutory incorporation. No doubt, because the MSME Act says that the award may be challenged under section 34 by virtue thereof. The Arbitration and Conciliation Act has been incorporated in the statute itself. Now, suppose if there is an arbitration clause, somebody jumped the forum and approached the writ court. If the objection is taken, can the writ court entertain? Because it's a 226.
But then again, it depends.
I'm thinking of purest case of the Supreme Court.
But my lords, what differentiates my case is the very premise I approached the writ court. Lack of inherent jurisdiction. And what was my case?
I'm again saying you can raise this point. This point is available, but only thing is the choosing of the forum.
Yes, ma'am.
Which forum you can challenge? We are on a forum. We are not on your right to challenge. Your right to challenge is there. It's ingrained, is vested in you. You can definitely. But can you choose? Suppose the inherent lack of jurisdiction. Approach the Delhi High Court. Inherent. Will it be a proper forum?
But my lords, my answer to that question is that because the premise is inherent lack of jurisdiction, I have that choice of approaching the writ court. Whether I should have approached the section 34 court under section 34 is a question that unless my learned friend can show a direct judgment on that, I still have the choice of approaching.
Oh, that's why, because it has some blending of a civil law. I'm talking about a civil law. inherent lack of jurisdiction that can even be raised at the execution stage under section 47. No problem. I am conscious. But that is a forum provided that the executing court is competent under section 47 to deal with because it relates to an execution of or executability of the decree. And if it is inherently, the court inherently lack, it's a no order or a judgment in eye of law. It's a non-est. It's a nullity. That is what Kiran Singh's case the Supreme Court has held. It's a nullity. And the nullity really, I say, unravels every aspect of it. There cannot be. But again, the writ court bypassing, and then too, when there is some restrictions imposed, if you have withdrawn without any leave to approach the proper forum, whether that will create a problem under Order 23, Rule 1.
That my lords will have to examine, because I am on the premise that my lords has articulated that because it's a nullity, as far as works contract is concerned, now there's no.
So you can go anywhere and say nullity.
But my lords, as far as
you have to choose the forum. Yes. You have to approach the forum, which is provided in the statute. You can definitely say nullity. No doubt that power, that right, or that plea cannot be shut down. But question is of a forum. Otherwise, it will create a floodgate for all in the country. If this is the position,
I could have raised it in the
then arbitral award 226. Then SBP, the 5-judge bench has to be thrown out. It says no 226, 227.
But in this case, now because of the very nature of the works contract, and there are several High Court judgments which the learned single judge has taken into account. There's no Supreme Court judgment on this aspect that a works contract is outside the purview of an MSME.
Sir, the question is entry. First thing is that you'll have to first ascertain the gate.
My lord.
Then you have to enter into the gate. If the entry in the premises is restricted or closed, can you go and say that these are not proper, because you have to enter into the premises, enter into the house, then you raise. Here they say the gate is blocked. You are not permitted to enter. How you can raise work contract not coming within the MSME, the arbitral tribunal wrongly usurp the jurisdiction, everything you can raise it, but before whom?
My contention is before the writ court, because
can show us that it can be when there is already, then a 5-judge bench has to be considered in this line. You are challenging an arbitral award under 226. This is what one has to perceive. Whether it will be permissible on whatever ground.
So
let us see patent illegality to extreme. Can you not raise this to a proper forum?
Again,
you have an avenue. You have an avenue. I do not know. What is the nature of the arbitral award? You know better. You have the avenue, but whether 226.
Yeah, but now, my lords, my challenge to the arbitral award.
If they put the award into execution.
The MSME assuming jurisdiction.
How the glycol has been diluted, appearing in paragraph 41. Is it a ground to dilate or dilute? Not dilate, dilute.
It comes down to
Supreme Court has deprecated it. Can't, should not. I think my own judgment is there. I have said no. I think it's a single bench or a division bench?
No, your lordship, division bench.
Division bench. So us.
One-ply.
So then would my lords give me a week's time to at least
that is a genetic problem with me, because I am so much vocal. The the moment I put a very difficult question, it really gives an impetus to an adjournment.
No, my lord, I've prepared my own compilation on the works contract as well as inherent right of
We will not.
jurisdiction.
That's why we prevented you whether we can enter into that aspect now. First thing is you'll have to cross the first hurdle
My lord,
to 26. You say that it is inherent lack of jurisdiction.
Yes,
226 is maintainable. Show us. Let us decide on that.
my lord.
If we say it is not, then a question of entering into the work contract or no work contract does not arise.
My lord, I'll take my notes.
I think you weed out those judgments which goes for a work contract. I do not think we will enter into
Yeah.
this
As
aspect.
far as the works contract.
Give me a jurisdiction or judgment.
Yes, my lord. If I could just hand over this. Now,
It
these are
contains all.
judgments, Yes.
It contains both.
It contains both.
That is
One
what-
on the fact that works contract is out of the jurisdiction of.
We said
It's all the
that
High Court judgments, my lord.
can we, again is a question of entertainability of that plea. Please consider there is a distinction.
My lord.
A plea, whether sustainable or not, is one aspect.
Hmm.
And the right to raise the plea in a forum is another aspect.
Mhm.
If the forum is not there, then again a nullity concept, which you are raising.
So if my lords will look at the compilation, at least for my lord's assistance.
Is a voluminous one. That's why I
Yeah.
just asked. Give me a pertinent judgment on that.
My lord. Oh, my lord.
I think we can ignore. I do not know. Up to 87, we can ignore.
My lord.
Yes.
Then my lords will look at.
And then
lord.
there is no dispute. Inherent lack of jurisdiction. I am conscious.
My lord.
Tell me, the forum is appropriate. 226. Where is the judge?
My lords, if my lords will consider from 184 onwards, those judgments on waiver of objection pay inherent lack of jurisdiction. That
Yes.
once there's a nullity, there's no question of waiver, which my lords is all.
Oh, there is, sir. That's why I say that it has a blending of a civil law. No difficulty, sir. I am
No.
conscious. I am conscious of those propositions.
My lord.
That so far as this cannot be waived, other two can be waived by virtue of section 21 of the Code of Civil Procedure,
My lords.
but not the inherent lack of jurisdiction.
My lords will then have.
Then 226 maintainability.
Yes,
You
my
just-
lords will have 219 to 374.
219.
Yeah, my lords will see at 10. Now these are judgments of
Yes,
the
219.
19.
Sorry. Yes. This is a single bench judgment of the Ahmedabad High Court.
My lord.
I mean the Gujarat High Court.
The Gujarat High Court,
Yes.
where the High Court interfered and considered the case of inapplicability of the MSME Act while exercising jurisdiction under
Yes.
227. This is the Anupam Industries, my lords, which my lords has at 219. When I come to 299, para 11. So that doesn't. It is pertinent to know that.
Yes.
I'm sorry.
Yes, I have read that Gujarat judgment. What for?
My lords, if I could take you through, then there are a series of judgments of high courts, and then I'll also take you through, my lords, the Vaishno Devi judgment on where issues of jurisdiction of the NSE Act have been dealt with in the jurisdiction. Now, nowhere has they considered that it should have been taken, at least my lords, subject to correction. It should have been taken under Section 34. And because I didn't take it under Section 34, I was
No,
precluded.
there is another aspect, factual difference. It is not that you approach 226 directly after that particular award is passed and assailing that. You approach section 34, which was the right forum.
My lord.
You decided to abandon that particular the proceeding and wanted to withdraw and then approach the writ court. So whether this fact can also be one of the factor, because
My lord, when we withdrew from the 34, we didn't inform the judge, we didn't inform the learned judge that we are approaching the writ court. We chose to abandon our remedy under 34.
correct.
And subsequently,
So what the law says, if there is a fetter which is created in the law, can that fetter be undermined, whittled down by taking a circuitous route?
and was understand what was following from the law.
That is what is there. If you look at Order 23 principles. Rule 3 of Rule 1 and Sub-Rule 4.
Order 23, my lord.
Order 23, Rule 1, Sub-Rule 3 and Sub-Rule 4. Rule 1 talks about abandonment.
My lord. Then my lord said Rule 3,
Sub-Rule 3,
Sub-Rule 3.
where the court is satisfied that it will be defeated by a defect and then permits the liberty. Then Sub-Rule 4 precluded you from instituting.
My lord.
If a bar is created, can you?
I understand what was following from my lord. So may I do this? Again, I'm not trying to, it's just I'm trying to assist the court because this is not something that is a straightforward question. So if my lords will give me 1 week's time, I'll come out with a note trying to produce judgments that might assist my lord. Because again, my plea of inherent jurisdiction is something I always had a choice. Now this 34, eclipsing my right to challenge on inherent jurisdiction, I'd like to come up with some judgments to assist my lords.
No, it is not. There is another striking factual difference which
No.
we noticed.
My lord,
Whatever the judgment you have cited, I have gone through this,
my lord.
and those are in the line of the judgment that upholding that Keshwanand Bharati's concept of basic structure, this theory that says that it is absolutely untouchable. This power of the High Court under Article 226 and 227 is untouchable. One cannot say that the approach cannot be made. And in that event, I do not know this 7-judge bench decision in this SBP Limited versus Patil Automation, I believe. What is that? Patil Engineering. That was a Patil Engineering or Patel Engineering. I do not. That was a judgment. Has been considered in a different way. Maybe 226 is a 11-judge bench, no doubt about it. There is no doubt Keshwanand Bharti's case is there. But here, if there is an absolute bar in the statute itself for institution of a proceeding after you withdraw the suit or withdraw the proceeding without any liberty, then whether 226 can be said to be maintainable or entertainable in that regard, because you can't bypass the law.
But
The
exactly,
law stands at your
exactly the question that the Honorable Apex Court has addressed.
So, my lords, may I?
Exact question. Why did fall from the lawsuit? With
So,
2023, volume 15. And paragraph 37.
Yes, so I'd like to know.
But sir, there is another very interesting, or I would say, the troubling facts have come. Even in India Glycol judgment of the Supreme Court, which you will be heavily relying on, that has been doubted by a subsequent bench, and the matter has been referred to a larger bench. In Tamil Nadu case.
Yes, ma'am.
Yes, my lord.
Yes, ma'am. But I'm not doubted this already. Upon that is not maintainable, then also it is reform. In that referral order itself, it is.
That's a view expressed by a judge, and then he says that since there is a conflicting decision which is operating in the field, so to have the certainty in law or to set at rest such controversy, let the larger bench be constituted and answer, so that it will be binding uniformly upon all the lesser quorum bench or an equal co-strength bench.
That Patil engineering cases is interpreted section 16. That it is within the domain of arbitrator.
Oh, that is the arbitral tribunal or arbitrator can rule its own jurisdiction. That is section. Even he can include that it does not come within the peripheral of the arbitration, because that's the distinction. The jurisdiction of the court is vested on the basis of a statute. And the jurisdiction of an arbitral tribunal emanates from a contract.
Well,
So the parties may waive the contract. Can they waive the statutory clause?
And that 226, whether 226, that 7-judge bench has held on the basic interpretation that it is always available under 34, because 16.5
There's no difficulty, but only thing is entertainability.
Yes, sir, that's what happened.
So there is a distinction between a maintainability and entertainability. If the entertainability has been restricted, it may be maintained, but court should not entertain.
That's right. That.
What do you have to say about this prohibition under sub-rule 4?
And so my lords are requesting for a week's time to get back to the court with this, because this is not some Raman issue, my lords. I'd like to assist my.
I think in a sunflag matter, we have considered all those line of judgments and ultimately held no, should not have entered into.
If your lordship should give you.
Because section 34 award was challenged under Article 226 in sunflag. We held that it should not. It's constituted in Tamil Nadu case.
On 50%.
No.
But completion of service of notice and 150%.
Come on,
It is,
come
it
on.
will come on 19th.
Yes, so. My lords, would my lords grant me 1 minute time? Even less than that, I just want to assist my lord on specific issue because
The Gujarat High Court, though correctly started, suddenly made a digression for which, for what, I don't know.
on this 34 point, I'd like to assist my lords and show that.
Assist on 23.
On 23, yes, my lords. Swollen from 23.
What is this?
The principle is what cannot be achieved directly shall not be permitted to achieve in indirectly.
Like what I get like recovering, trying to recover about on the basis of this, the clients are trying to recover about 5 crore rupees from fixed time cost, and that's it. I have filed an IA 4612 at flag E. Not asking for stay of that impugned or lost it is in the ways of clearing, but at least if they are now trying to recover it from my all bills.
My lords, as far as this is concerned, his goes beyond the whole purview of the petition. But all I'm saying is,
What beyond the whole purview?
subject to my lords, if my lords directs us,
The award was in their favor.
yes, my lords.
By this impugned judgment, the award has been set aside.
Yes, my lord.
Now you are contemplating to
But what they are doing is
they execute and recover that amount. And when you find that is a very difficult question now to answer, and it is one of the debatable question, then will you still reap the benefit thereof? And
Already
put them
taken
to
my bank guarantee.
jeopardize?
Is bank guarantee taken, but I can make a statement as an officer of the court that if my lords gives me a week's time, in this week's time, no action will be taken.
No, we don't mind.
I think it's very
You
fair.
say, yes,
No
that
action,
should be.
because I'm
That
asking
should
for
be.
it. It's on my, no further action will be taken. I'm asking for a week's time.
Like certain, the certain I'm asking.
I won't take more than 15 minutes. Manoj.
15 minutes.
15 minutes.
Can we do it?
10th minute.
That's 15th is what day? I mean, text is no. Tuesday is what? So put it on 13th. 13th.
And also we can say that no further coercive action. Because if they take
Further, use the word further.
because I'll get you.
No, if already taken, then you can't have.
Obligement.
Item number 4.
Looks, pursuant to my last directive, passed on 14/10/2025, we have filed an affidavit here, where we have dealt with all the 3 points highlighted by my lords. You have served a copy on my learned senior, the amicus curiae. But so far as the petition is concerned, she is appearing in person, so I can only serve a copy if she comes from there. Otherwise,
Oh, in fact, it was here.
she's on the.
Oh,
That copy I have received, I have something to say in this matter. Because today I realized that there are tearing urgency in the matter. But I have received messages from the petitioner in person through WhatsApp.
yes.
Every day, 1,000 to 1,500 trees are felled. And by now, 50,000 trees are felled without complying with requirement of any law.
What are you doing?
Steering urgency. And today,
That is not
Today, your
fact.
lordship sees the position in the Cuttack, Bhubaneswar, Twin City throughout Odisha, Baleshwar. Pollution has gone such a level. My primary reason is this. They are felling trees today.
Yes.
Lord, I can show the WhatsApp message received from the petitioner today.
No, she's appearing.
Yes.
I don't know. I know.
This PIL concerns Milord Sambalpur Wildlife Division. That is Milord regarding.
No,
the-
sir. That does not mean it may be restricted to a particular place. But in course of the hearing, if we notice, can we not enlarge the scope of the
Yes,
public?
definitely.
After all, it's a public interest litigation, is not an adversarial litigation.
So let
So we can definitely say, but
let
failing
them give the details. Milord.
of the trees indiscriminately, and then
Yes, Milord.
now we are all grappling with the,
Milord,
I would say, the menace of this pollution or the air quality.
Crossed daily.
Can't you have information from your DFO?
Cuttack and Bhubaneswar has crossed daily.
area, which Milord, they are
Has
saying-
crossed?
Crossed daily. That's what they're reporting in the news.
More than
Air quality.
500.
Yes, air quality. Bhubaneswar is serious.
300 on.
They now they have stopped construction from night till morning. All construction works are stopped. They have stopped burning of tree leaves on the road for the purpose of fire, and they have stopped sand on the road. Also, the orders of preventive measures they are taking. But felling of tree, which has become a menace,
Oh, she's a.
they have not taken any single step. It's a menace now. Not I.
What is this going on? This is we can't.
Milord, that cannot be, Milord.
Cannot be. What are you talking? And they are saying that it is a reality.
Details, Milord, I'll obtain
It
instructions.
is here. I have got the Bamra and Bargat Forest Division. Today the information is every day approximately 1,000 to 1,500 trees are being felled. And after filing IA, near about 50,000 trees are felled. And I have got a video to that effect also. This is the video. Yes, please.
No, that is the news, some news that.
But whatever, there cannot be.
There cannot be. There cannot be. If
A
this is
news
taking
without,
place,
I can
it is not.
understand that it is not a devastating fire, but there is already a spark. We are concerned with the spark
Yes,
also.
Yes,
We
Milord.
can't leave. We
Milord,
can't.
if
He says that 1,500, the numerical number may not be correct, but there is a felling of the tree
Yes.
is a reality. You can't avoid it. Even one tree you fell without any following the procedures, that really invites.
That is what.
No, that cannot be ignored in this way.
Your Lordship is surprised in the affidavit. They have not said anything for your Lordship's order as to formation of the state level committee.
No,
They have
we
not
have said it.
Six adjournment.
Third week of.
Item number 6.
Minus I appear for the appellant, minus.
Limitation that dismissed is going to appeal court and get demand. But the collected judgment was challenged in the writ appeal, my lord, and that has been dismissed, my lord, on merit of provisional.
Minus I appear for the petitioner, minus. Minus, can I seek a pass over 5 minutes, minus? My colleague is there with the physical copy of few documents and the judgment, minus. He is in another court, he'll be there in 5-10 minutes, minus. Minus, there is an order of this honorable court whereby the court has directed similarly situated employees like me to be regularized, minus. Under writ petition 11006 of 2015, minus. That order was challenged by the court, dismissed by the then Chief Justice, minus, and they have appealed before the Supreme Court, but there no relief has been given to them or nothing has been done by us.
Yes, who is for the appellant?
I appear for the appellant, my lords.
Now the similar question has already been decided by a coordinate bench earlier on merit.
My lords, I'm not aware of that, my lords, but I have an
That is
order.
in case of Dasarathi Hembram.
My lords, I'm not aware, but there, my lords, there is an order.
Common judgment was passed by the.
Batch matter, this thing, so the case. One of them.
Sir, in your matter, the batch of the writ petitions were disposed of. One of the common writ petitioner approached the appellate court, and appellate court on merit has dismissed. Then there is a common judgment upholding the judgment.
Manus, I was not there, but for a moment, Manus may give the liberty to give two orders.
Mr. Naik, what my lord has said, have you understood?
Yes, Manus, I
In
get.
a batch matter, you were one of the parties there. A common judgment was passed. Amongst them, one approached before this appellate court. So, in writ appeal, in Dasarathi Hembram, that is first man,
Manus, I get.
first petitioner, in your batch.
But my
In your batch, that first matter, writ appeal number 552 of 2024, that was dismissed on merit.
I get it, but my case is it's different. Factually, my case is very different. That's why I moved a separate appeal, my lords.
What different?
My lords, I'll tell. In all those cases, my lords, they did not have an order of an Orissa Administrative Tribunal stating to consider the case. They did not even say. I have an order in my favor of 20th March 2020, my lords, 20th March 2018, directing the state. My lords, my colleague is there. He'll hand over that order to my lords. And there's an even similarly situated people has been regularized under the orders of this court, my lords. Writ petition 11006 of 2015. My case, my lords, I worked seamlessly for 14 years. Manifestly, my lords, under an order of 2004 of this court, they dismiss it after 14 years, my lords.
No, what are you talking about? What is this?
Madam, this is an order of this Odisha Administrative Tribunal where I filed a petition for seeking regulation.
Sir, this is what is a simple direction for consideration and disposal of your the representation. Nothing more than that.
Madam,
Not mean the court have the authority have to decide in your favor.
No, I'm not even saying that, but my lord, it has to be seen this
So what? There is no difficulty. One approaching the tribunal and getting securing the order of consideration. does not really makes any changes where the authority or the person approaches the court directly under the writ jurisdiction.
Miles, I get it, but Miles, just see the date of the order. It is post termination. The date of the order.
Whatever be the reason, now once you have approached the court and the batch of the writ petitions were disposed of by a common judgment, and on a factual or merit, the court does not find any substance, then can you stand on a different footing because you secure an order of consideration or representation?
Miles may even consider for a point. Miles have the order of this honorable court
The
itself.
court has said that all these appointments was at the post which was sanctioned subsequently, and there was no nothing which was followed. Even a plea was taken that no show cause notice. The court says not required.
I get all the points, Miles, but please consider my case on this point.
No, sir.
Miles, our order of this court only.
Show us whatever the order.
Miles,
What order you want to rely?
Miles, please, and Miles, in the judgment of Uma Devi, just 2 paragraphs of
Uma Devi, you consider what it says.
Miles, Uma
The
Devi.
illegal and irregular, the distinction was drawn. Nothing more than that.
How can my appointment be considered illegal?
No.
Miles, just see. Miles, may I read this? 19.
They were appointed as a Shiksha Sahayok.
Yes, Miles. Shiksha Sahayok.
Yes.
Miles, the Honorable High
The
Court.
government appointed more than the vacancy advertised.
No, Miles, I was part of the.
Whatever.
Miles, see the order. This order itself gives that regularize this because I have worked for 14 years. Uma Devi also says even if there is they have worked for more than 10 years, Miles, it has to be considered.
This is the crux.
Miles, why should I be faulted for the state mistake? The state did the mistake, the procedural errors. I bona fidely applied.
That is dealt with.
Miles, I have worked.
That is dealt with by the appellate court.
Miles,
That is this court, division bench, in writ appeal, in first matter, decided that issue which you are raising now.
But Miles, there is an order of this court which grants regularization or similar situation.
No, definitely not regularization.
Miles, may see the order.
It never says, it simply says that if there is any benefit is extended under the scheme, you will extend the benefit. That does not say regularization in the post.
The last paragraph.
Definitely not.
Admittedly, since and this order is challenged by the state, no relief has been granted to them, my lord.
No, nothing.
Miles, because I have under this, Miles have to consider on a sympathetic ground also. Miles, I worked for 14 years.
And para 9.
Yes.
We will quote that saying that.
In the same line. Nothing.
Miles may consider sympathetically. I've worked for 14 years, Miles.
That's all. Yes.
Abruptly, I've been the action of the state is manifestly happening, Miles.
Keep it. Yes. Yes. Hearing concluded. Yes, sir. They passed the order today itself.
Dispose.
Deeply obliged, Miles.
Yes.
Item number 7.
I may be pardoned. I am hearing VC. I am raised.
Regarding submission of property statements, which is the precondition.
Oh, this is that.
Yes. Now the portals.
We have all submitted.
Recollect, this matter was listed before vacations, and I brought to the notice of the Honorable Court. Now the portals are open by the General Administration Department, so that all the officers, they can submit their property statement through online mode, because they are given with.
I understand. What will happen?
By 31st.
What will happen to their right of promotions from that group?
But after they submit their property statements, their cases will be considered for promotion.
From effective from?
For that particular year. No, my lord, for the subsequent year, my lord.
Why?
Subsequent,
Now-
I have always.
And you are disrupting the seniority.
What I am praying, my lord, let them submit their property statement.
No doubt, they will submit. There is no difficulty, but
That can be taken care of by the Honorable Court. That is what I am saying.
because if they have their right of promotion that accrued because of that particular, the extension, then in that event,
But I'll, then your lordship may kindly appreciate. Well, the rule says the property statement is a mandatory requirement. As per rules, time frame was given. Granted,
True, but their case was that it has been extended and they were within the period of extension.
no, my lord, but
That is what the single bench has also recorded. They have also produced that particular copy of the,
no,
if we remember.
that document also your lordship directed me, so also them
So-
produce. I produced that document.
True.
That was only in respect of the CCR, not in respect of the property statement.
Right.
And a statement was made that the last date has been extended. Although the last date was up to 31st of May.
I think it was 26th of a particular day.
Below 20th order. Below
My lord, that is the order passed by the Honorable Single Judge in the first set of writ petitions,
that is
which are also the subject matter of challenge in the present batch. My lord. There was no instructions issued by the department extending the date.
Your lordship may kindly
The
have.
date was only extended up to 31st May, my lord.
What he wanted to do.
29, 2025
Your
order.
lordship may kindly.
But that is also under challenge.
Right.
So
Prior to it, it is the admitted case that.
that is what I really wanted.
State has given extension from time to time.
Oh, that is what is this major difference. According to them, that extension is not for the purpose of property statement.
No.
But
The last, not the last one. Previously, for giving property statement, even after the last date, they have granted extension.
Extension was granted invariably from 2024 till May 2025. They could have availed the opportunity.
when they submitted.
They straight away approached this when the nomination.
No, I am asking when they submitted offline or in a physical mode, when they submitted the property statement.
The court has given an interim order to give offline. They didn't object to that.
Oh, I understand.
No.
29.
Writ petitions were disposed of on the very first day. Your lordship may kindly see the third matter in the present list, my lord. That is Ananta Charana Nayak, WA 1613 of 2025. Page 36, if your lordship may kindly see.
Which one? WA?
WA 1613 of 2025.
Yes.
The lordship may kindly see page 36. This is the order passed by the
Give
Honorable
that
Single
file of
Judge.
1613.
1613.
My lord, I am here in BC. May I participate, my lord?
You have a senior here or no?
My lord, I have a different. He is fighting for.
So let us first ascertain what he says.
But only one document will be sufficient to establish the entire.
What document?
My lord, there is a circular issued by the.
Where is the circular?
That circular may I share, my lord? I mean, if you will also permit, I can share.
You are addressing 1602.
Your lordship,
You are addressing 1602.
Yes, sir. Annexes are same.
No, we have to take up that, otherwise pagination, page marking would not.
You are talking about 26 September order?
Yes.
Yes.
But may I place?
This is the impugned order.
Yes, sir.
So that is true, no doubt.
I only point out only two things. May I place the order paragraph 3(1) and.
That is what I remember. That's why I am saying that you have cited one particular, the letter shows that it has been extended beyond the time.
Yes. That is why I want this.
Yes.
It is clearly contended in the bar that the last date for submission of the CCRs, that is confidential character, with due acceptance of the property has now been extended to 21 sheet. Today,
today. It is also fairly contended that in the meantime, the petitioners have already submitted their property statement details offline on 29/2025 and 21/9/7. It is accordingly contended that taking into account the extension of the date of submission of the CCR to 26/9/2025. So made by the state police worker by the letter dated 25/9/2025. Concerned, Superintendent be directed to submit the CCR by accepting the details of the property statement so submitted offline on Kodak. So the contention was that since you have extended the date for CCR and the DPC was not meeting prior to the submission of the CCR, because they have to not only take
They have to take into consideration the CCR.
CCR. So no prejudice will be caused. We have already submitted the property statement on 20th.
I got your point. I got your point.
Then, my lord, paragraph 4. Additional government advocate also fairly contended that the last date of the submission of the CCR has now been fixed to today. And if the petitioners, as contended, have already provided the details of the property statement offline on 29/2025 and 21/9/2025, this court can pass appropriate order in the light of the order passed on 29/2025. Then accordingly, the order has been passed. So,
Where is the order dated 20th of September?
Your Lordship, class 10 also. Two copies I have handed over.
That is under challenge in WA 1613.
That is right. Then once you have accepted.
Let us see what is the order.
1613.
Oh, yes, I got this. Yes.
Have you Lordship copy?
Yes.
Will I please?
No, just give us 30 seconds time to.
Okay.
Where is the 7/9 letter?
7.
No, no, there is a reference of a letter dated 7/9 in paragraph 6.
I am asking what is whether it has been addressed to the data.
6.1.
7/9/25.
That is there in the writ petition. Writ petition annexer 1.
No.
See 1613. Writ petition.
Yes, sir.
Annexer 1.
7/9 लेटर क्या बोलते हो चाहिए?
अच्छी सर पाइलू सर annexer 1 to your writ petition.
ये हुआ.
Your name is appearing in this annexure 1? Letter dated 7/9.
You see,
Whether your name is appearing?
say, in the list of that 687 candidates.
Yes.
Yes, no.
Yes.
Yes. Because your lordship says that the period, experience period was reduced. Therefore, the zone of consideration went up. If it is reduced, those persons who has not submitted their property statement prior to this relaxation, they should be given an opportunity because their name was not there to submit property statement.
No, whether your name was appearing in 687, I am asking you a very simple.
Those who are given, so this list will not show both name because that marking will come down.
Yeah. He says yes. His instruction is yes, but unless I verify, but I don't dare to make a statement.
No, list is before me. I am just, can you give me a serial number of your, the respective petitioner?
The read petition, para 4, they have stated that their name appears in the
634. Serial 640, page 40.
Total
634, page 40.
Is a Kavita Nayak. 634 is a Kavita Nayak. So I take it that everybody.
I am just,
So that is 1613.
16.
Serial number?
Oh, first case. First one is, no, we are taking up your case, Kavita Naik. Kavita Naik is 634.
Another is there, the other scene, sound.
22 is a Jajoti Keshwari Sinha.
Rajati Kesari Sahu, 164.
I was saying 22 is a Sinha. She was saying Sinha 22.
578, the other Singh Sahu.
578.
So I take it their names are there. They have not disputed them.
out of that list, those who had submitted their property statements and their CCS were up to date, they were considered for promotion and given promotion. As far as the petitioners are concerned, but the petitioners.
This is what, in order to fill up the vacancies in the rank of the Inspector of Police for the year 2025, the nomination rolls of 687 as on the date of the special CSB may be please furnished along with the CCR as on 31/3/2024 to this headquarter through the respective range officer, which shall be received by the headquarter on 21/9. positively for consideration of the promotion to the rank of Inspector of Police by holding the such and such for the year 2025. Now, the CCR must be submitted by 21/9. It has to be furnished CCR as of 31st of March. So CCR must have been completed by 31st of March. You extended that particular period by 26th of September. CCR.
Is not extended. Only the persons those whose CCRs were part CCRs were available. Or
You have not
originals were-
said that part CCR.
But that is the circular which has been.
Nothing-
taken note of
nothing
by
was
the
then.
Honorable Single Judge. Your Lordship, may kindly that circular
Is going round.
which the Honorable Single Judge has taken note of, that was last occasion it was produced by me before this Honorable Court.
And the court has considered this and says that once you have extended the time for a CCR, then what is the difficulty in not accepting the property details report?
The property details, Your Lordship,
I understand that in view of your own circular of 24th of June 2021, you have made it that it is a prerequisite condition for promotion. I understand. I got that clause 10 of that particular letter dated 7/9. He has said that as per the principle outlined under the Odisha Government Servants Conduct Amendment Rules, published on 24/6, up-to-date filing of the property statement is a prerequisite condition for promotion. I understand. But now the question is that if they have submitted, then in that event, you cannot say that they have defaulted. And the reason has been given in 20th September order because they are working at the field and where the accessibility is very limited. They could not produce it online because you have started online. If you say offline, they would have filed it. And then subsequently they filed it offline. Be pragmatic in that way.
the department is not against anyone. Department has considered those cases, those who have genuinely uploaded and updated. And
One time did accessibility and one comment by virtue of the court's order.
senior associate me,
And your Lordship sees
Let him.
how they have played.
Let him.
Lordship may kindly see that writ petitions. Your Lordship may take up the writ petition 1613, where the first order of the Honorable Single Judge is the subject matter of challenge. That is the third.
20th September order.
Your Lordship may look at the writ petition itself, the writ petition, the arguments made in the writ petition, why I am trying, what I am trying to appreciate. Your Lordship may kindly appreciate that. What is the submissions made? Para 8, if my lords would come to para 8. Para 8 of that writ petition.
What is the number?
That we have also enclosed as.
No, what is the writ petition number?
The writ petition number, my lord, 26489 of
Yes.
2025.
Correct.
Lordship may kindly come to page 8, para 8 of the writ petition.
Yes.
And if your Lordship will mark that this writ petition has been filed in 2025. What para 8 your Lordship may kindly see, that it is submitted.
No, they have said that this amendment rules requires by January 2025, they have to submit the online.
Then para 9 your Lordship may kindly see.
Yes. The remote area of the Kianja district.
Yes, para 9 your Lordship may kindly see. Though he submitted his property statement in the previous year, due to technical problem, he could not submit the property statement in 2024 in the HRM.
Then he says that he wanted to submit it because of the closure of the portal that was not accepted.
That was, and when the petitioner tried to submit the hard copy of his property statement in 2024 after closing of the portal, the same was not accepted. The next para, your lordship may kindly see that as the petitioner could not file his property statement in 2024, he is going to be debarred for consideration for promotion to the rank of police officer.
So
What they suppressed in the writ petition, that they were granted extension from 2024, my lord, from 1st of January 2024 till 31st of May 2025. That they didn't disclose, my lord. And if your lordship may kindly appreciate the documents also I have enclosed where the extensions have been granted in the writ petition itself, in the writ appeal itself. Because we could not produce these documents because the writ petition was disposed of on the very first day. So we could not produce all these documents, although we have made submission denying their claim. If your lordship may kindly see annexure 1.
of
Annexure 1 of the writ appeal.
yes.
This is issued on 30/12/2024 by the General Administration Department calling for the property statement. This communication was given to all the departments, including the Home Department, where now under which the present petitioners are serving. Then next page 19, your lordship may kindly see 31/12/2024. Here you are requested to bring to the notice of all the employees under your administrative control and ensure submission of annual property statement for the year 2024 online through HRMS portal, latest by 31st January 2025. The next year, lordship may kindly see page 20, 19th April 2025. This is the extension. And there they have indicated all the extensions which were granted timely. After careful consideration, government has been pleased to extend the time limit up to 28th February. However, it has come to the notice of the department that a large number of employees are yet to file their annual property statement as by above deadline. After careful consideration, the government has been pleased to extend the time limit up to 31st May 2025 as one last chance for defaulting employees. So, making a statement before the Honorable Court that in 2024 the portals were closed, so we could not make. That is absolutely a false submission made before the court. They could have brought it to the notice of the court that yes, extensions were granted and we could not submit. This has been widely suppressed before the Honorable Court. And if your lordship will look at the order passed by the Honorable Single Judge, your lordship, that is at page 36. Page 36. That is order number 1, my lord. On the very first date, the writ petition has been disposed of. They were referring to the other writ petition, but this is the first order which was passed. Your lordship may kindly see para 4.1. However, it is contended that since all the petitioners are field workers and accordingly they could not avail the benefit of online submission, the authorities are not accepting the property statement details of the petitioners offline. 4.2, it is further contended that unless and until the property statement details of the petitioners is accepted by the concerned superintendent of the police with due submission of the CCRs along with the said document by tomorrow 21/9/2025, petitioners will be deprived to get the benefit of promotion. And it is contended that all the petitioners are ready and willing to submit the property statement details offline before the concerned superintendent of police in course of the day. It is accordingly, and these writ petitions were only filed when the nomination rolls were called for. They thought that now it is high time the authorities have called for the nomination rolls. Our cases will not be considered for promotion, or we will not get the promotion once the property statements are not made available through online. So they approached this Honorable Court, and this Honorable Court by suppressing the fact that extensions were granted. And they don't dispute that it is a mandatory requirement under the rules,
How did you
both under the condition of service rules, the criteria for promotion rules, so also the government conduct rules. And if your lordship would look at that amendment of 2021, this is also made applicable to all, including, I would say to the extent it may not be to the judicial officers also. This has been made applicable. And I am not against them, not the department is against them. Whoever has submitted, they have got the promotion. Now the opportunity has been given by the department because the portals are open. They can avail the opportunity. Let them submit. I'm not against anyone. Government is not against anyone because vacancies are there. Police.
But no, you are not addressing that which my lord has said. They will lose everything. Let us adjourn the next month. First to complain better.
We have no problem in complying online also. But we say that let them be there. Those who are promoted rightly, wrongly, let them be there. In my opinion, they have overreached the court's order, Miller, because they filed the writ appeal. They filed the writ appeal. The writ appeal was
best what you are saying, but since they have extended,
I am not there. They are not extending, Lord. They are extending it for the vacancies of 2025. We are.
What Mr. Das is saying.
Mr. Das is misleading, Lord. His submission and the document is something
I have
different.
never misled this honorable court.
Mr. Das.
1 minute, my lord. Let me give.
Counsel, it is not. He is very clear. He has not misled. I think
No, your lordship has.
that word should not be there.
Sorry, I would.
What he has said that whatever has happened has happened. Now he has opened the portal. Now you can also submit whatever the property details online. He's open. Now you can submit it. But he has not assured that what will be done on the basis of that today.
Yes.
He is silent. Rather, he is I think some kind of a dissent has come from him in this regard. Another question is, the first thing is that once in 2021, the mandate is given that it will be done now, then you have complied from 2021 onwards. Only for 2024, you could not submit. The reasons have been cited by you that what is the reason you could not submit. We will definitely consider in that light. But if it is online and the portal is open, at least you can upload it.
We'll
You upload it, come back on that. Let us see. We will definitely ponder upon them. The two things they have to consider. First thing is when this single bench judgment was staring at their face. And the single bench judgment is very much categorical. There was no stay of the operation of the judgment was passed by the appellate court. Then whether the action of the authorities in proceeding in haste and doing the exercise just to forestall the entire thing, whether that can be justified. We have to see that.
Yes. All right, we will fix the deadline.
We have to see if they do not agree, is there any post vacant for that year?
Yes.
Which you have not filled up by promotion.
500 posts were there, that's only 400 some odd posts has been filled up.
That is what I am saying, that what about the writ petitions? I am thinking in that line, sir.
No, I understand your logic.
May I submit, Miller? Few lines, if I am permitted. May be permitted, Miller.
What?
Well, in this regard, my answer is very innocuous answer, Miller. We have all submitted the property statement as per the fresh notification, Miller. We have all submitted.
So very good.
Then they are on their own circular.
But the others, your client may have done it, but others have not done it.
Now, all of them. My client has many. All of them submitted.
Not after for this year after opening the portal.
Yes. After opening this portal, as per before vacation, my lord said. After vacation, my lord suggested, as per Mr. Das, also he suggested that to file our upload our in the portal. We have uploaded. Rightly, we have uploaded on the first day itself.
So they have already uploaded it. Then
All of them are submitted, my lord.
So, then is there, with regard to Miller, their promotion.
All of them has not submitted.
My lord, they have.
no, online. I'm talking about. He's talking about online.
He's talking about offline and telling.
No, he's talking about online.
Online we have submitted.
Yes, he has submitted. His client may have, but that's why he's saying that everybody has submitted.
No.
So the first you submit.
Yes.
You submit. 31st has not gone. Still you have a sufficient time.
Yes.
You just submit it. Let us come back. Let us see that what their stand is.
My lord, my 1 minute, Miller. I have submitted. My clients have submitted. My clients have submitted.
Whoever has not submitted out of these writ petitioners, they are permitted to submit.
Yes, ma'am.
Those who have already submitted.
Submitted. Then Miller, there is a circular by them. There is a circular that is 27/11/25. And I have sent in the WhatsApp. If your lordship be kind enough, my associate will hand over this. Just for a moment, I am reading out. What is the circular? It is innocuous. It is my lord, just kindly bear with me. This is the concluding suggestion by the government.
That is the trouble of online. Whatever you are saying, all those documents have been given to us. We have taken into consideration. But so far as your client, you have given him a good advice in advance. He has complied. But others may not have given that advice. So they wanted that when the time is still left, portal is open, let them also submit it.
My lord, others means once. Mr. Senior case, Kavita Naik might not have given, but all the clients of mine, they have all submitted.
Yes. So
Living fellow.
We will record a note of appreciation that your client has submitted.
But to that, Miller, in addition to this, with due regard to his advice, Mr. Das, Saswat Das advice, Miller, just have a glance.
Why?
This circular,
All of you are standing on the same footing. when the still the time has not lapsed, let the others who are represented, let them also upload it. And thereafter, we will take into consideration all the cases together.
Only one circular will be sufficient to resolve all the issues, my lord. This circular is 27/11/25. My lord, that is available with my associate. Your lordship can go through and I can read out it.
Kindly look at the last paragraph. They have themselves stated that those who are defaulted, they will be granted seniority and other. Last paragraph. In case of defaulting employees, last
Employees.
has your also got it?
If any defaulting employee.
Yes.
Sir, have you noticed one word? He is happy.
Yeah.
He is happy. If you want, I can pass an order on the basis of last paragraph.
No, we would rather have an order.
No, we will pass an order on the basis of last paragraph, if you are happy.
No.
My lord, just to that, I am giving one my lord's assistance in interpretation.
That is not.
Okay.
No, that is what Mr. Ross says.
He has agreed. He will. He will here and now agree.
No, man.
Only what?
You have said in the last paragraph, if you submit now, subsequent DPC will consider.
No sufficient. No subsequent DPC, my lord. In this DPC, we are entitled in this DPC.
The last paragraph of that.
We are entitled in this DPC.
Your lordship may kindly consider the last paragraph. If any defaulting employee submits the required property return after DPC within the grace period means 30th.
Within the what is the grace period?
Those who
So
have
what is the
submitted
grace
their
period?
property statement within that grace period allowed by the government and is found otherwise suitable for promotion, his or her promotion may be considered in the subsequent DPC. He may be granted notional promotion. So this
This was issued in the month of November 2025. What are you talking about? You are talking about the retrospective. If somebody has already submitted the the property statement within that particular grace period, then his CCRs are considered and he will be accordingly given. Then there was no necessity of issuing this particular letter. What was the necessity? If somebody has submitted the property details within the extended time, matter ends. He will be considered in an ordinary manner.
Yes.
Then what is the utility of this subsequent DPC? Why? Why, sir? He will be considered in that DPC because the DPC never happened before the May 2025. Never happened.
So this has to be read in consonance with this.
That is what there was no necessity.
This is 29/12.
Correct.
Extending the period. So extended period.
By the honorable court.
The promotion was granted on 8/10/2025. Thereafter, they have issued.
No, sir. Then I am telling you kindly visualize the situations.
Yes.
Your case is that you have extended the time for submission of the property details online up to 31st of May. Whoever has submitted online the property details, he will be coming under the zone of consideration for promotion. It will be an ordinary exercise undertaken by the Departmental Promotion Committee. There is no question of giving retrospective effect. It will take effect from the date of the seniority. And there was no question of any subsequent DPC to be considered. That shows that whoever has not submitted within the grace period of times. But if the time for filing the ACR has also been extended.
Extended by the government.
I am telling you by the government, then beyond the time, they will be considered because of this letter of extension which you have opened the portal.
Notionally from the date.
It says that they will be considered in a subsequent DPC.
Yes.
But their seniority would be notionally taken from the date when they becomes eligible.
Yes.
I think to that extent somebody will give up some actual monetary benefit, but his seniority would remain.
Yes.
If they agree.
Yes, that is Miller. We agree with that. That is your contention.
They will not get the actual monetary benefit for this year, but their seniority in the promotion will be maintained.
Seniority that
We have We have availed the
No,
grace
no,
from
it is
the
only for the purpose of computation of all the increment and all, everything that will come. But for this period, you will not be getting an actual monetary.
Area,
Okay.
but
Okay.
prospectively will be
Yes,
getting.
will. Yes,
Area
will.
pipe and na.
No, I will.
The area will come.
The paragraph 3 is very clear. Paragraph 3 is very clear.
We have availed the grace from the honorable court. That is the grace.
So no difficulty on this basis.
Well,
This is what I am saying, well, let them all submit.
Submit. You submit online? No difficulty.
my statement may
That
be
is what it
recorded.
is.
I have submitted.
A suggestion has, no, sir, they will fix in the first week of, because 31st is the last. So first week of February.
They want the, your lordship have
Unless you-
that it is the extended time. In fact, this is the press opening of portal. So your lordship may only say.
This week constitute to be grace period.
Let us see. You can't.
Shashwat Das is trying to mislead us.
Yes, it will come in the first week.
Obviously.
Item number 8.
So just to remind my lord, I think that LIC housing finance matter, the lordship have pleased to hear it at this admission stage. You know, lordship have pleased to hear it at this admission stage. Of course, I was swimming against the tide in this matter. Your lordship took a view, so it's according to the rules in it, doesn't. Item number 8, notice has been issued. But I was swimming against the tide in this one. I was swimming against the tide in this matter. So I was just trying to bring to my lord this matter will take up sometime a week after sometime next week. So that I'll try to impress upon my lords by filing a piece of calculation. The differential cost which I'm going to suffer, it can be managed or compensated. The Honorable Single Judge has directed to pay them 10% additional. Only that equity that can impress upon, otherwise not.
First time
Two
I have
weeks.
instruction to appeal, so it's a copy we solved on me.
Yes, sir. 2 weeks.
Item number 9.
The lawsuit has been placed to issue notice on the draft of the
On whom?
That is respondent number 2 and 3.
It has been delivered.
OHPC,
It has been delivered. The indication
Yes.
shows.
Odisha Hydropower.
My lord, in this case, high level committee will examine matter, that is what the direction was given by the honorable single judge. So I have to take instruction whether it is disposed of or not, that is not.
There, I'm appearing in SLS, not disposed of, it will take further time also, because there is a direction for press investigation by scrutiny committee again. The lawsuit may
So
kindly,
they are not appearing, then what to do? 2 and 3 are not appearing. Service has been affected. Item delivered on 26/12.
I have for the Adish, I am not.
I understand you are for the respondent number 1.
One.
But 2 and 3 are not here. Though the service has been affected upon them. Then what to do? They have to proceed and decide in their absence.
The orders, I think, order impugned is very innocuous,
9/5.
isn't it?
The 9/5 order.
So earlier one, which is 59,
No.
page 59.
Annex 9, shares 55.
No, 59 is the portion where 5.1 and 6. Earlier, there is some direction in another case, 7/3/2025, in 4774 of 2025. Then that is followed here.
In this case, also the order impugned is Annex 9. That is at base 55. The ordering person is at 58. My lord. That was my lord. I am submitting.
59 is the ordering person, sir.
My lord.
Para 6.
Para 6. my lord. That is, I pray this for your lordship. The lordship may kindly.
Just. Has the committee taken up the decision?
Paragraph 3 is what?
No, I have understood. I've seen the order.
Paragraph 3.
So what? Why you are sitting over?
That will be disposable in terms of order dated
7/3/25
Annex 50, my lord.
That has
But
gone.
What has happened to that 9, by September you have to dispose. I will take just the instruction, let it come day after tomorrow.
Why you are not taking an instruction?
That order is there.
Which one?
Power is there.
Not reflected in the cost.
Which? Who is appearing? Mr. Rupesh Kumar Kanambo.
DP number. DP number senior advocate.
But name is not there in the
Ah.
cost ratio.
The cause list does not been reflected. You can.
Oh, he has already entered appearance by filing Vagalatnama, but the cause list does not show. Come in the next week and let me.
Reflected in the name of,
Petition for
in the cause list.
Who are you?
I'm for the I'm the complainant. What is scheduled is waiting for this case.
What complainant? What is your right? In this subject matter, the committee is already in session of the matter. What do you have to say? Complainant? Let that application be listed, thereafter we'll see to it.
I remember 60, 2020.
Just find out. Next day.
Appeals.
Give it a copy to him.
Yes, ma'am.
Then
Item 10.
Three matters are there. Three matters are there, madam.
you are appearing in both the three matters, all the three matters?
2 and 3, other one is also the same matter. I am appearing to the court. First matter, that I just need 2 days, in item 2 and 3, we have an interim order in our favor. The coal transportation contract and site verification certificate was not being granted for that.
Now it has been granted.
My lord,
in
I
one-
for the opposite
let-
party,
let-
number 1 to 3, my lord, the wrote the tender.
Just-
Item 2, the WPC 3 to 917 2020-25.
No, he is appearing.
He's appearing, filed the counter affidavit. In this case, they have prayed for non-issuance of site visit certificate.
Correct.
In the meantime, my lord, when the matter was taken up on the day your lordship the board on the 19th, itself, we issued the site visit certificate.
Oh.
So in this process, the writ petition has become infructuous. And another prayer is there to expound to not the clause 3.1.8 was introduced. They have challenged the clause is non-essential clause. But in the process, the site visit certificates in terms of that clause, once they have issued and have complied the documentation and we issued the certificate, to that effect, my submission, subject to my lord's conclusion, the writ petition, subject to transportation of coal to Hindol, has become fructuous, and so far Kamakhya Nagar is concerned, my senior is appearing in Kamakhya Nagar 2 matters, identical cases. Let the matter be placed.
What I need to, I will just praying the lines. I just need 2 days. The joinder is there. My friend has got it. I have to wait it. For professional reasons, I have to wait it. I have not yet waited it. Now, 2 days, I find that solve the joinder my normal friend. Matter will be taken up on Monday or Tuesday, whichever day suits your lordship. I will dispose it of. Can be disposed of.
Tuesday, your lordship,
Tuesday.
Tuesday.
It is submitted by the senior counsel. You got the name? I understood. On that day, we will dispose of.
Also covers this case.
True.
Because
We
they
will
cannot
dispose
challenge-
of on that day. We will
My
dispose
obligation.
of.
Item 11.
All matters come on Tuesday.
Not directed. File counter in item number 4.
In the meantime, that means.
Item number 11.
What?
But in this case, I am the appellant, my lord. I don't have any objection if my lord and friend is asking time and your lordship is granting the time. Your lordship, can you see the last order? Your lordship, can you see the last order dated 29th October 2025? Your lordship has admitted the appeal. The question of law that whether the chapter note came into effect on 1st March 2011
Retrospectivity.
can be given a record. In this regard, what I submit, my lord.
So there are two things which I have perceived. You have no objection for their adjournment, yet you argues the matter and cite a judgment in your support. So this kind of a the dichotomy which I perceived. Please frame up your mind. Either you have an objection to the adjournment, we will hear out the matter.
No, man.
Or-
What I submit, because that chapter note 4 itself is challenged before the Honorable Supreme Court and is pending.
Is there any interim order passed by the Supreme Court?
No, man. Only notice has been issued.
So, is there any fetter on the part of the High Court to deal with the matter?
Yes, your lordship can dispose of, but
That is what I'm thinking.
only my submission is that if at all, let us for the sake of argument, I'm just submitting law. If at all the Supreme Court has held that note 4 is not the process of manufacturing of ores into concentrate is not manufacturing, then your lordship decision will be academic.
That's a fait accompli. That will be a fait accompli. What is that? So there is no necessity.
And basing on that, other
Not required. Adjournment next Tuesday. Now, when is the
Next 15th.
15th?
Question is something different.
That is what
Perspective of not.
we have recorded that. I think.
Item note 12.
Wait, please. In this case, export services may be.
Yes.
Let's in this case, export services, let's rendered by me to Facebook Ireland, Facebook based at Ireland, Dublin. They are being sought to be taxed despite they being zero rated services. And this is, your lordships will take your lordship's order at or dated 29/6/2022. Daily order dated 29/6/22 of your lordship, where questions have been framed by knowledge.
Your lordship, in this case, I am conceding to some extent. Your lordship, if your lordship will permit me.
That's what has happened during pendency for the immediate next year.
So he's squeezing the zone of consideration. He says I'm conceding to some extent. Let us see the magnanimity of some extent.
The lordship, during pendency in this petition, my lord friend has challenged the audit proceeding, your lordship. Consequent to audit, your lordship, the assessment proceeding has been completed, the assessment order has been passed. During pendency of the writ application, the petitioner has filed one IA. Your lordship, that IA number 6563/2024. Your lordship may kindly look into that prayer of that IA.
What?
Your lordship, in that IA, the petitioner has prayed to set aside the assessment order, impugned assessment order consequent to that audit for the impugned period, your lordship. Because in the subsequent period, already the assessing officer allowed that. Your lordship, to that extent, I am conceding. Let it go
That
to
once he allowed, then he has to be.
No, your lordship, what to some extent I am conceding, your lordship. Why I am saying so? Because in that period, in which the assessing officer is allowed, in that period he has produced all the books of accounts, your lordship, participated in the proceeding, investigation proceeding, and that has been allowed. In this year, even the audit has been conducted, he has not produced any document. So my respectful submission, let him appear before the assessing officer with all these proofs.
See,
Let's take my prayer.
what is the question framed here?
Your lordship, I am
See,
It
again,
is beyond the
again we are going back.
territorial jurisdiction then.
No, limitation. Question number 3.
That is covered.
It is just like, under
The
what?
audit report being not
Under
compliant.
what?
No, that is what is, I have not seen.
If audit report itself goes, then there is no
everything
basis
on the-
of why, how can we relegate him to?
You are not as right as at your lordship, that is 7 days submission.
Understood.
Here it is 4 months, your lordship, and during that period the COVID was there.
What there, what was there?
COVID, Your Lordship, during
Oh,
COVID.
so that,
Pandemic, Your Lordship.
that the
And
limitation
COVID
period was
Sir, have you,
kept in abeyance.
see, in 2022, around 4 years,
Your Lordship.
at that time I was new
Your Lordship.
to the bench. 29/6/2022, we have framed questions. Have you made any response to that?
Your Lordship, only
Have you
we have submitted.
doctrine of non-traverse?
Due to
Doctrine of non-traverse.
Your Lordship, only COVID pandemic, Your Lordship.
Doctrine of non-traverse.
Only we have submitted. Your Lordship, by bound.
Since you have not complied with that order,
I think
Have you-
there is one judgment of the Supreme Court.
Your Lordship, during that period, and we have
that judgment will not really extend the period of limitation.
yes.
There is one judgment. Acceptable.
No, that is what
that has been referred to larger.
larger.
Because that.
Yes. Understood. That is what.
Yes.
Shreyan's case.
Shreyan's has been passed by 3 judgments. For that reason, that has been referred to. That is
So that it is not this case. This is audit report. Suppose our court. Factually, you have not responded to.
have only submitted only due to COVID pandemic.
Overall,
Can it be? There is a judgment which does not save those time.
Shagufa Ahmad is
Can you-
against.
During that here.
Where are there judgments directly on that point?
Only.
So far as this,
Shagufa Ahmad.
the
2021.
assessment parts are concerned, I believe, if my memory goes and does not betray me, there is one judgment of the apex court on that.
And Your Lordship, for a moment, Your Lordship, a kind of paragraph, the audit report itself says that due to COVID, that could not be completed 127. That's because audit, Your Lordship, as Your Lordship knows very well, it is a participation, Your Lordship. So, Your Lordship, the place of visit, Your Lordship, audit is in the place of visit. And thereafter, and also, as per section 65, also says the commencement.
When the audit commenced,
Audit, Your Lordship, commencement.
I'm asking you, what is the date of the commencement of the audit?
Commencement of audit was 10/2/2021. 10
No.
February 2021.
No,
10 February 2021.
No. 6(8) to the commencement, the proviso says, Your Lordship, the proviso of
Commencement is 10 February 2021. That is at page 105 as per section 65(4).
comments, I'm sorry, I'm not with my learned friend. Section 65, Your Lordship, for a moment, Your Lordship, may kindly do.
Section 65 proviso says the date of place of visit or the date on which the last document submitted by the petitioner, whichever is latter, that is the date of commencement. Section 65 proviso, Your Lordship, not the place of visit.
That actually, that is why I said
Your Lordship.
it goes non-traverse. You have not.
No, 65 what? 4.
65 for the explanation.
Explanation.
Your Lordship. Sorry, explanation. For the purpose of this subsection, the expression commencement of audit shall mean the date on which the records and other documents called for by the tax authority are made available by the registered person or the actual institution of the audit at the place of business, whichever is latter.
No,
So here, my
when you have visited the place of business.
Your Lordship, the place of visit is that the conducting audit 19th January 2021 to conduct the audit on 10th February 2021.
So you visited on 10th February 21. That is what he says.
See, that is visit. But submission of document, whichever latter, Your Lordship.
So which is letter? Submission of document is letter or
letter?
On 6/8/2020.
Submission of document is
I'm
letter.
coming. When he talks about letter, that creates some kind of a problem to him. If it is earlier, I can understand. If it is letter, again, yes. What is letter? Tell me.
Subsequent date, Your Lordship.
What is the date?
That is the date.
Tell me. When the pandemic was.
Was not there.
That is what I was saying. The pandemic was not there.
Sir,
It has eased out. It has eased out. It has eased out. That is concern. That's why when you say latter, then say, give me the date. Better. He was giving earlier date. Now it's latter date is more important.
Now from the audit report, you will see. Latter date is 6th August.
6th August. So 2021. What was the scenario in the global?
Report is given in 22. May 22.
What was the scenario in 2021 August? There was a complete, I would say the functioning. Everything was functioning in 2021. What are you talking?
From 20 to 22,
that is the period of limitation. Again, I'm saying there is a judgment. I'm talking about the pandemic. The pandemic is struck on 26th or 20th of March 2020. And there were 2 phases where there was a.
This is the second phase.
No, no. That was the latter part of 2020. Was the second phase.
Sir, offices were being virtual.
I've got.
Yes.
And
the judgment.
I have been working there. Each day I was going, except April 2020. Every day I was appearing.
Have you got? No.
This is Sagufa Ahmad is there.
Shagufa is 167 to CRPC.
No.
That is not available for the department. The Honorable Supreme Court's extension period is not applicable for departments.
That is what is here.
Statutory requirement cannot be.
That is what I'm saying. Supreme Court has said. If I correctly remember, there was. Then in that event, you can't take advantage of COVID.
That is first phase of COVID.
When there was a total shutdown and there was no, there was no.
That relates to an NCLT.
That is default bill.
No.
It's an NCLT.
NCLT procedure.
NCLT. Okay.
Justice Oak.
Justice Bobde, Bopanna, and Ramasubramanian. Authored by Ramasubramanian. Justice.
Another one was also there. Section 167(2) default bill. if investigation is not completed within 90 days. So that also Madurai High Court, Madurai bench of Madras High Court
Actually,
that went
is
to Honorable
unfortunate for my part. It is unfortunate for my part, Your Lordship. Why, Your Lordship? For two periods, 17, 18, 18, 19, for two periods, audit was conducted, Your Lordship. In the audit, he has not cooperated. Anyhow, he has not cooperated in the audit.
You understand?
Your
He's
Lordship.
a
Only now, Your
he's a
Lordship.
very bad assessor.
Your Lordship, it was on the
No,
ground of limitation, Your Lordship.
That is what I'm saying. He's a bad SSC.
Let me clarify.
He's a non-responsive SSC.
Why?
He's non-cooperative SSC. But
Your Lordship,
if the statute has created or whatever,
due to
then will you not?
let's see,
Whatever.
for the subsequent year, 18-19, the matter has been referred to investigation wing. Investigation wing has given the report. And this period, in spite of non-cooperation, Your Lordship, the audit has been completed, Your Lordship. But during COVID was there and non-cooperation was there, everything. For that reason, I have considered that let it go because subsequent year has been allowed with a thorough verification.
If the foundation is shaken, then what will happen? The castle will fall.
Ultimately, it will be allowed. Your Lordship, ultimately on merit it will be allowed.
Why the assessing officers will be burdened with passing an order ultimately when you know this order cannot be sustained? Why? They are also human beings.
Let him produce the books of accounts. At least.
So what is this? If the audit report has not been filed within a statutory period of time, then the audit cannot be accepted. That is what the main question. And the basis of assessment is the audit report. So
can be this limitation on the face of in the teeth of limitation.
21, 6th August 2021 to 13th May 2022. That is total of more than 9 months. That is insofar as the timeline. So it's not a case that I am a recalcitrant.
Let me take one adjournment because I have not produced the record, Your Lordship. Only counted, Your Lordship. Let me only one opinion.
That's why I have been asking you. I have been asking you.
Your Lordship, I know.
You have not actually
I just want
to
escape, Your Lordship. I just want to escape.
It is not pure question of law.
Your Lordship.
Limitation is always mixed question of fact and law, unless you demonstrate on facts.
Because
so when he has last produced the documents and records, so that that is Hajira or time whatever.
That so far as the commencement date, I have to verify, Your Lordship.
but you were so vociferous, so much vocal in taking us to whichever is latter, and now you.
No, since my Lord friend of January, it said that January.
No, February he says.
February, for that reason.
At any rate, whatever be the date of his production, you have taken 3 years for completion of audit.
No, complete 3 years.
2019 to 22.
21 they started. 21 started. 22 latter part of the 22 they submitted.
The answer is at page 127. It says audit has been conducted.
I have already shown.
On the base business of the company. Statement has been recorded and books of accounts have been verified from the statement recorded on 6/8/21 such and such as and such. So statement verification everything over on 6/8/21. As for the
that is a commencement.
That is commencement. From that there is plus 3 months time.
3 plus 1.
3 plus 1. But
subject to extension.
Subject to extension.
No, extension has not happened.
There is no extension.
Not extension.
It has not happened. So and they filed it after that.
Yes, it is filed. The audit report is prepared on 13/5/22.
May.
After August, May.
That's true. So virtually
9 months.
9-10 months.
Again, that 65-4, the same type of language
as 42 of
where 42-6. Provided that where commissioner is satisfied that audit in respect of such a registered person cannot be completed within 3 months, he
may extend another 6 months. That's all.
period of
And not beyond that. But this outer cap is also given that he cannot give an uncharted right to go on and then extending it.
No extension 6 plus
But
3,
this-
9 months.
Where is that?
That means there is no extension.
There is no extension.
Sir, Odisha रे आदि
What verify? Nothing verify.
3 मास ଭିତରେ extension
No,
हवा
yeah, actually, Your Lordship, I thought that I'll escape in that way. I only one.
सर कोब्रा अनुसार 3 मास ଭିତରେ ହିଁ extension हवा दरकार सेटा केबे भी नथुओ
Before the period expires.
Your Lordship knows very well, better than me.
That's why I said Cobra is against in his favor.
One of the three views. I know I'll lose, I know, in either way, Your Lordship. But since the matter will be settled, Your Lordship, so I
Subject to his convenience.
That's a request by my learned senior, because I would never stand in the way. But because it's completely up to Your Lordship.
You are very positive then.
It's not that, plus it's just that it's probably a case of fait accompli. It is on the face of it, it is delayed and doesn't really save the proceedings. On the face of it, it is delayed. There are recent judgments of my lords also on that issue of this of the in the case of Raman Enterprises, Bateman Engineering.
When the limitation was lastly extended, 23 or 22 by the Supreme Court in the Suamoto PIL.
Well, that's up to 28 February
22.
No, not February. 90 days for filing.
For filing.
Filing. So May 29. So before that, audit report has been prepared. If you take.
But that is for 90 days is for filing.
90 days. So around 29th.
Yes, plus that is 90 days for filing.
10th January 2022.
That is why I know in the meantime there was one judgment that came while that was there relating to these obligations under the statute to do a particular thing within a time frame. And then the Supreme Court has said that does not, because what he says is absolutely when my brother is there, so far as this submission of the FIR and all everything is concerned, because that was held to be outside the purview thereof, if I correctly remember.
That is Kasi. AASI. That is, there was the difference of opinion in Madras High Court and Madurai bench. There were two.
The Kasi judgment is there that talks about this
167-2 default bail.
In any event,
You check up.
proceedings are going on. During this COVID period also,
But you are not appearing, no?
6/8/21 I appeared and I am in fact I am imploring you to start the date from 6/8/21.
What he says that you never appeared thereafter. Once they have visited your premise, thereafter that continued. Audit continued.
No, nothing continued. 6/8/21 it says.
Have you given any intimation, sir? Continuation. Have you given any intimation? So that
we have given under taxpayer stated he will produce FIRC and BRC on that day, not produce.
Your statement must have been recorded, sir, by the authority. Your statement that you may not have produced here, it may be there in the record. He must have signed it. That I will produce the rest of the records which are not available with me now before the authority concerned in the office. That normally they state that.
Your Lordship, in one hand non-cooperation and another hand principle.
That will not save you.
See, for me, I'm.
It is only factual thing we have.
So my submission in that way, if Your Lordship, I can be escaped.
Unless he agrees.
Very difficult.
Unless he agrees.
Very difficult.
No, he has filed a mistake. Your Lordship, I kindly look into the
He
IA.
agrees to go back.
No, the IA when he has filed. The IA, after formulation of all his questions, after challenge, after passing of the consequential assessment order, he has himself has filed the IA. Your Lordship, for a moment, may kindly look into
Mr.
it.
Misra,
What for?
you could not get it.
What for IA is fine.
IA is filed, Your Lordship, to set
What?
aside.
So,
Not on that ground.
what of then?
That Your Lordship, prayer, his prayer. Let me place the
Whatever,
prayer.
that for a subsequent year that has been allowed.
Your
And
Lordship,
what is the ground?
dispose of the repetition by setting
Can-
the order under DS level.
Can a litigant not take an alternative way to achieve the same destination? What is the difficulty?
Para 2 of that IA.
Your Lordship,
Para 2 of that IA.
any such other.
Para 2 of that IA. You are drawing our attention to prayer. Para 2 of that IA.
As we
65
pass any such
6563.
order or orders as we will.
No, sir. Para 2.
The questions frame.
You are reading from 6563 IA.
Your Lordship.
Para 2.
Paragraph 2
sir.
of the said IA, please.
He has quoted the order.
Quoted for.
Interim order he has quoted. Thereafter he has made this is subsequent event. Department may proceed. So you quash it. Correctly.
Your Lordship, for confirmation of the dates, Your Lordship.
Confirmation that the date is confirmed. Whatever the date you are showing, he is agreeing.
Your Lordship.
Initially, he says the 10th of February, you dissented. You say 6th of August, he says agreed. 6th of August. Yet you are beyond time.
Your Lordship, no, 6th of August in that audit report itself. But Your Lordship, what happened?
What is there? Can you belie your own documents?
Sometime in the order sheet.
Please tell me, can you belie your own document?
No, Your Lordship, not at all.
Your own document says 6th.
It's the submission before Your Lordship. In some cases, Your Lordship, I just, it can be confirmed after going through the record, Your Lordship. I'm sorry, I have not, Your Lordship, only one opportunity. Because in the record, Your Lordship, sometimes some accounts has been called for and he has assured to produce the subsequent date. So for the confirmation of that.
Is this the explanation saves that?
Your Lordship.
What?
Because the commencement, accordingly, the commencement will be.
What?
Counter affidavit.
Your place of visit at the site. And the documents, did you not collect certain documents at the time of the visit?
You know, to audit.
Audit
we
means-
cannot forcibly.
Have you not gone through the document? What statement you will record without going through the documents? What statement? There must be something from the record. There should be something which is discernible. You will ask those questions and seek explanation. You have written that the oral evidence, what he was saying, the oral statement was recorded.
In audit.
What is the purpose of the recording the oral statement?
Meeting this profession and some applications are under challenge. The virus of that is pending. (168A) notifications, where are they?
Your Lordship.
Have they not extended the time of assessment?
Your Lordship.
Is this case covered by that or not?
Notification number 56 and notification.
Then what are you arguing since last half an hour?
This was because of the pandemic.
This was ordinance, then where are the notifications? It has come up to 2022. Those notifications. That is a virus of that notification is under challenge. Certain cases are pending.
Notification.
Then what are you arguing? Till now. This is 1718 and 1819. Yeah. You are not drawing our attention to 168A and notifications.
Which empowers. No,
They have in fact extended.
must have.
No.
Otherwise,
You are not
the purpose
verified.
of incorporating this. Purpose of incorporating is
168.
168.
Force measure.
Yes.
must have, because this was incorporated during the COVID time. Must have issued it. Otherwise, it is a farcical or absolutely of no use. The exercise is futile. True. I have seen the date.
I don't to file.
Date of incorporation.
31st March.
That is what I am saying. Date of incorporation I have seen. Neither you are drawing attention, not he is drawing attention.
Yes, it is.
हियरिंग डे फिक्स करके लाभ उठा कौन? हियरिंग डे फिक्स करके लाभ उठा कौन? This is how you are getting ready and prepared. It is our preparation.
Adjourn for 3 minutes.
Let's since that notification is there, then
It is there, sir.
yes, so
Virus are challenged.
think further to be verified.
We are still 2-3 high courts. They have confirmed. It is intravires. 1 or 2, I think they have dissented. Isn't it, sir? You are arguing that matter. Allahabad High Court, I think, is in your favor. Lengthy judgment has been passed. Kerala High Court and Allahabad High Court. They are against you.
And that issue, Honorable Apex Court has taken.
So that will suffice this case to decide.
Yes, for the next.
Because in that event, it can be decided by way of the prayer in the IE. So that it can be disposed of.
You come prepared with those notifications. He is not drawing that attention.
Will come. Will come.
Yes.
That's in the next item that is there.
Item is not
That is has to be wrongly tagged.
Wrongly tagged.
It is wrongly tagged. An income tax.
Which one?
Sub item.
Item 12.
That may be detagged and maybe called on some other developers. It has. No
Which item is we have taken?
GST. Income
Item
tax.
12. Yes, that is 2449.
So, detach it. This will be listed. This will be listed in the next week.
Yes, this is not identical to the matter. So it will be heard separately.
Matter.
In the first matter, interim order is extended till the next week.
Matter.
The second matter. Second matter.
Not first.
First.
Okay, second matter. Interim.
Item number 13.
Yes, my lord. I got a written note of submission. I will take up 1652. 6 First.
Yes.
Item number 13 is obtained. Teams.
What is the noting?
It is stated that it's a single bench. The noting
And at first it went before.
What it was before
Oh,
single bench, then it went
yes.
to a division bench. See, division bench, then it went to single bench, now it has again come over here. So it's up to Lordship to decide whether it will be a single bench matter or division bench. Lordship sees the notings in the.
What is the voting?
In the list is given in the law.
Where is the note?
The last, a single bench matter.
A single bench matter.
Why you have
I don't know, man, but it has first it went before Honorable, how it was on, for Honorable Justice. And then matter from there, it has come to the newspaper.
But interim order was passed by Honorable Single Judge. That is 1/2/2023.
That is a confusion between matters arising out of tender and post tender, that is work order matter. Now, if it is matter arising out of work order and other, it is now, my lord, Honorable
single bench?
single bench.
And this is relating to
Underloading charges
underloading.
arising out of a tender.
It is underloading charges arising out of a tender. Tender may have participated, we are L1,
Also,
we have completed the
so
work.
it is arising out of a work order.
Now work order. It is entered.
So it has to go to single bench. Where do I get these classifications?
Sir, order.
Where do I
Rules,
get a
rules.
classification?
High Court rules. See it.
Oh, classification list is there.
Yes.
Huh?
The following matters may be heard and disposed of by a single judge. This is help.
I do not find there is any case relating to these from the list, chapter 3.
In assignment, my lord, it is written, rate petition relating to dispute on work order other than tender.
Where do I get it?
In the
That is assignment.
In the assignment.
Assignment other than.
No, I am just talking about the rules.
Yes.
There should be something. I do not find from this chapter 3 any kind of a distinction. Yes, where do I get it? It is updated. Subsequently, 2019 one.
Here it is there. Let it is updated.
Which year?
So this is updated till 25. नहीं नहीं सेतर नथी हम इंटरनेट रे अछि ओडिशा हाई कोर्ट साइट रे ओडिशा हाई कोर्ट साइट रे रूल्स जो अछि एथि गोटे रूल्स अछि ना ऊपर ऊपर सेठी गोटे रूल्स अछि देखंतु होम हिस्ट्री जजेस तब रूल्स अच्छी यस दैट ऑल कस बस हाई कोर्ट ऑफ ओडिशा रूल्स not explicitly page 6 question
Volume 1.
हाँ सेटा volume 1 page 6 question
Same thing.
Same thing. It is not that.
It is not.
So other than this, will be division bench.
Division bench.
But in the assignment, my lord, it has been stated, I should bring it to my lord's notice, that it is stated in the assignment that writ petition, other than writ petition, that to work order, other than the tenders. That is what the language is like this course like this.
Can you call this this step?
So this assignment is.
No. I don't know what is that.
So petition relating to disputes on work order other than tender.
Put flag B. Flag P the endorsement accounts.
Like D or B? P.
Full name.
So that is why then it has to, I do not find, then it is a division bench which is the competent.
Noting is it is a single bench.
No, it's not noting. It says that after re-examination, the matter it is found that the case is related to a tender and therefore.
No, I am reading from the list, my lord.
That is the wrong one. That does not create how the determinations or the roster is created to take up the matter according to the rules of the High Court.
I read reading the noting of the list.
You check up that instrument to take up the instrument. There you say, come down below, flag P.
Sir, if there is a discrepancy in the assignment and the rules, which will prevail?
The rule.
So why you are going by assignment? There may be a mistake.
No, just what we are doing. Otherwise,
that is dealing assistance noting, which is earlier one. So that remain. So subsequently, dear judicial has verified, dear judicial has. You check up that. That is why I said.
The connector cases are seen.
How?
The connector cases are connected to this case. Those are not. So is that for the last case is degree.
This.
Suppose to set a tag also the similar matter. So the division means automatically. Dear गोटे जगह लिखिथिबे अन्य जगह लिखि नथि तनकर डीलिंग एस्टेंट सब जगह सिविल में लिखि दिछंती ना आगुरु डियर अंकर अछि 17/2/2025 रे सिंगल बेंच में दिछु यो आस्थिला से कंफ्यूजन नॉले इसमें डिवीजन बेंच सुना अबाउट if it is not specifically mentioned in rule chapter
It is
3,
not
rule
there.
1,
True.
then obviously it is division bench. Obviously.
No, sir, I was just thinking about the rules. The rules does not make a distinction between a matter concerning the tender or matter concerning the work order. If it is no distinction, then how can the distinction be made?
How the camp reporters have been showing on till date. For some matters, they are sending it to single bench, some matters they are sending it to the division. Camp reporters are showing the same. Even though we say it's a division matter, division
No,
bench
because
send you single.
maybe because they will go by that particular the description of the roster, which is absolutely a wrong one or faulty one. So that has to be corrected.
Many of the tender matters.
But I do not know if there is any judicial order. I do not know whether there is any judicial order which says that these matters should go to the single bench. Then which one? No. That is the order passed in this matter. I am just talking about the omnibus general order, where the court has said that these type of matters will be taken up by a single bench. I was just thinking in that, like a practice direction, we call it a practice direction.
Actually, originally, learned single judge has taken up and granted stay, and he proceeded actually. Thereafter, after some days, after some orders being passed, it is reflected on 11th February 2020.
Was decision taken by a single bench, disposed of by the single bench, that again it has been challenged now. One of the matter I'm today, because disposed of by the single bench. They have again re-challenged that top. 1654 is also earlier disposed of by the single bench. Another matter that is also earlier disposed of by the single bench. If the Lordship sees that WP
Anyhow, then you delete this matter from the rest. Yes. Go. Seen the report of the department indicating that apart from WPC 1654 of 2023, the other connected matters pertain to the roster of the single bench. Stop. We had given our anxious consideration to the provisions contained in Chapter 3, Rule 1 of the rules of the High Court of Orissa, which contains the repository of the category of cases to be dealt by the single bench, wherefrom we do not find that the matter concerning the issue relating to the work order shall be taken up by the single bench. Any matter not enumerated in Rule 1 of Chapter 3 of the said rules shall be taken up by the division bench of this court. There appears to be a discrepancy in assignment of the category of cases which led the WPC 1654 of 2023 to be listed before the single bench, despite such category of cases is not included in Rule 1 of Chapter 3 of the said rules. In view of the above, the other matters except WP 1654 of 2023 be detached and be placed before the single bench, having appropriate roster. Actually, what we use the term is the determination, actually. But here it is a word roster which is used.
Mr. Lordship notice. So far as item number 3324 is concerned, it was initially taken up by the division bench.
Yes, ma'am.
Then it went to single bench. Now it has come to division bench. Lordship may see 3324 of 2020. The item.
No, it should go back.
Maharaj.
3324
of 2020.
I do not find 3324.
Yes, ma'am.
Huh?
Below.
Oh.
Yes.
Open.
Lordship seeing the order dated 12/3/2020.
That is division.
Division.
No, it should not. Whatever there is. Yes. And this is pertaining to what?
This is all, my lord, with regard to the issue pertaining to underloading, my lord. Underloading charges. My lord, the first matter, only one matter, my lord.
So how that will go to a single bench?
It will not go, my lord.
Other matters?
Other matters will not. If this matter is
all the
taken,
matters issued
only
in the state.
except one matter, my
Except
lord.
one matter.
That is related to NCC.
Which was?
4388 of 2017.
That one matter, my lord, is different, and that has become important.
Which one? Open.
4388 of 2017.
A different matter, it has become important.
This is a renewal and extension of the
Yes,
bank guarantee.
this has become important.
So will it go to the single bench or a division
My lord,
bench?
If he is saying that it was pictures, let him file memo and we will.
No, this is relating to the NIT again.
Again relating to NIT.
So again, it is a tender. So whatever, then it relates to a tender.
Relates to a tender.
So then automatically the division bench. Why not? So
file memo that it is, you will not press this.
no,
it is
that's the wrong keep watching.
This I don't.
Other matter except when WBC wants in favor of 23 be detached and be.
No, it's not. Then earlier, wrong order. The half-hearted, half-baked argument was made.
This matter was also considered an interim order was passed by single. This 43.
That time, my lord, what happened, my lord,
was
that
entertained
time-
by a single bench.
That was, it was being entertained because, my lord, single bench at that time, read petition arising out of civil matters where, my lord, tender was not a part. It was arising out of a contract. So in that capacity, my lord, on single bench has passed that out. We're back in 2017.
What I presume,
My lord.
the code numbers were placed differently, so it had gone to.
On the beginning, seeing the report of the department indicated that apart from
Indicating, not indicated, indicating.
indicating that apart from WPC number 1654/23, the other connected matters pertaining to the roster of single bench. Stop. We had given our answers consideration to the provisions contained in chapter 3, rule 1 of the rules of the High Court of Orissa, which contains the repository of the category of cases to be dealt with by the running single bench. Wherefrom we do not find that the matter concerning issues relating to the work order shall be taken up by the
Single bench. Correct.
any matter not enumerated in rule 1 of chapter 3 of the said rules
shall be taken up by the division bench of this court.
Correct. Then
There appears to be discrepancy in assignment of the category of cases which led the WPC 16/23 to be listed before the non-single bench.
correct.
Despite such category of cases is not included in Rule 1 of Chapter
This
3.
is having not, despite such having not included, is should be having not included.
Not included in Rule 1 of Chapter 3 of the schedule.
Correct.
Next, in view of the other matters, except
No. Then you start up. Stop. The council appearing for the respective writ petitions, appearing in the respective writ petitions, echoed
one matter that I should bring it to my lord's notice. That is 15202 of 2016. Though my name is being reflected, but they have taken away that file from me. That is 15202 of 2016.
in this batch of petition.
Yes.
Writ petitions. Then who is appearing?
Nobody has appeared.
So can we take up the matter in their absence?
Then
if they
I have to
taken
take their instruction, my lord. Then I have to call them to say, ask them whether I should appear or not.
No, they have taken away the brief. Have they taken a no objection from you?
My lord, because that was my instruction from my office that they have taken away the brief.
No objection?
No objection, my lord. But still my
Certificate, then how can you appear?
My lord.
Even why you will ask whether to appear or not to appear?
My lord, that is another thing.
When they have taken?
My lord. I think, my lord, 2-3 years back, my lord.
Then by this time, any wakalatnama, fresh wakalatnama is filed in that matter.
No, item 6.
Dismiss for default.
You have filed you don't.
He cannot.
No
Record
objection.
his submission.
No objection.
My lord, what can I do? One thing, my lord, let it be taken on next Wednesday. I will, meantime, I will just call them to know that whether they have given any other counsel or not. Because they are from the same, I will just inform them, then they can engage some other lawyer also. I'll just inform them that whether they are.
Yes. 21st then.
Right.
All the matters. Yes.
Item number 14.
And in the item 15, I'm praying for my pastor.
Sir, what is the use of keeping a 1 day for hearing?
Let us pass on the people.
What? Who?
Stas. Sorry. 1,000.
Where is she?
That is on the leg.
What do you say, madam? Passover, they are asking. Passover.
Item number 15.
Is 49 15, both of them. Passover, difficult is problem.
Passover.
Item number 16. Yes. Item 17.
How much time you will take for argument?
In this matter, arguments were earlier concluded. The arguments were reserved. We had filed, both of us, we have filed an agreement.
That is order dated 7th July.
Then why it is listed?
Listed to direct further filing of citations.
Yes.
Everything I have filed.
We are filing recent judgment. I come regarding blacklisting. No. City.
But it is with you.
The blacklisting without following the procedure.
What is this?
We are also recent judgment regarding
Recent it's
blacklisting.
recently we have said blacklisting. This block of portal.
In the case judgment regarding
Regarding that clause C, read the OCW before, whether it has to be read, it can be read disjunctively or conjunctively, that is also another issue. There also we have.
Yes, that's
It has
regarding disjunctive.
Clause C of the OPW. Whether it has
So it was not really reserved for judgment. It was not. It was substantially heard.
Yes.
Oh.
I just dictate the case of this and just within 5 minutes. The petitioner who is a contractor registered under the PWD contractor registration rules, he awarded 2 works. He awarded 2 reconstruction works.
He awarded. Yeah, he was awarded.
He was awarded.
I got confused with this.
I stand by.
Yes.
The construction was he could not complete it. The termination order was passed under penalty clause 2B. So he preferred a writ petition. During pendency of the writ petition, a show cause notice was issued under clause PWD code 31AC, not achieving milestone. Not achieving milestone for blacklisting 3 years, 2 show cause into 1 is the another also. He replied, the matter is sub judice before this honorable court. So thereafter they did not take any action. Subsequently, this honorable court extended permitted to file the
Extended the time to complete the
complete the
construction.
work 8 months.
Okay,
So
then
then state prefer SLP. But by that, after the order, blacklisting order was passed. State
again you are creating a confusion. The matter was the writ petition was pending before the division bench.
Yes.
The division bench, in the meantime, they issued a show cause notice.
Yes.
That why you should not be blacklisted. You intimated them that the matter is sub judice.
Yes, Lord.
So they kept mum.
No.
But you did not file reply.
No, I actually informed no reply, no specific reply.
It was fine. Then
Then
what
it was-
happened? Then the division bench extended the time to complete the construction work.
Yes.
Then what happened?
Then Lord,
They challenged the order before the Supreme Court.
Yes, Lord.
Then what the Supreme Court did?
Supreme Court remanded regarding penalty matters. Supreme Court said regarding there is a extension and penalty. Court passed that extension and remanded about the matter regarding penalty deposition of
Means the extension of time was quashed by the Supreme Court
yes.
and remitted the matter to the
Extent of penalty.
to the authority
No, this honorable court.
to ascertain the penalty.
Penalty.
Yes, but the matter was pending.
Matter it is pending. Sir.
I mean, before the show cause notice was issued, there was no order passed for debarment.
No, the blacklisting order was immediately after disposal of the writ petition.
Okay.
Before going to SLP order. In between, after disposal of the writ petition and before passing of Supreme Court order, that was an actual
So according to you, once the time was extended to complete the work, then this order in the interregnum was
Yes, Lord.
that cannot be passed.
Yes, that is one of the grounds so and then advance argument was based on the condition provides tender condition as well as the OPW provides the twin conditions. One has to not complete the not achieving milestone and substandard work.
Oh, the word "and" is there.
And
So it's a conjunctive word.
And they focus was notice was
Only on one incident.
one instant, and the final order was also blacklisting order one instant.
Right.
And this honorable court, any identical matter, exactly same issue without any inquiry. This is and this honorable court pleased to say the other person that the blacklisting order is stayed. Identical matter which I already
Stayed.
Stay the blacklisting order.
But he has not set aside. This is the interim order.
But yeah, lots of the reason have been assigned this regarding files. That's the way I'm so.
No, that is this bench.
No.
No.
That you lots of just you lots of the same condition. You lots of this page number 2, the condition constant or non-achieving of milestones on insufficient imaginary are not adherence to the policy. So this is the similar paragraph 5, the rules they have submission. So this has not been also final order, but basing on the interim order on we said this continue. But I am with so in this case counter is filed, your lordship. And here is a case also where no inquiry was conducted. The recent judgment of renewable setting, your lordship, this honorable court held that when you are invoking the OPWD code, the condition OPWD code guideline provides you due inquiry by the chief engineer, which also absent in this case. So I I submitted that renewable city judgment, your lordship.
Okay.
Recent judgment. I have given paragraph 12/6, your lordship.
Which
renewable
city? Yes. Paragraph?
Paragraph 12.6, your lordship.
This is with regard to something else. Factually.
Total blocking and blacklisting, both. Here is only blacklisting order is challenged. Paragraph 12.6.
There, the thing is, you have delayed in submitting the security deposits.
Your lordship.
So that was the context.
It was the renewable city case. He has not deposited the additional performance.
Oh, I know. That is what is a different one.
Yes.
Your case is a different one. Your case is the blacklisting or debarment because of not achieving the milestone. You says that the clause says the milestone and the substandard or whatever.
Yes, sir.
The quality is there. So absence of the other does not invite any debarment proceeding to be initiated against you. That's your only answer.
And number 2, not inquiry. That which is renewable.
Secondly, you say that inquiry is inevitable. This is a very mandatory one. Having not done so, then it has to go.
That's one. Yes, that is the.
As far as that conjunctive and disjunctive is concerned, is our argument that it should be read disjunctive because both the it is not always possible that both the circumstances will satisfy all the time. But at the same time,
Why don't you put it in a separate category when you have put many categories there?
that the authorities will take care.
No, what take care?
But
Roman 1, 2, 3, 4, when you have put, you could have done it. There is no difficulty in achieving two things together. There is no problem.
This is executive instructions.
Executive
So,
but
so that should be very lucid to understand and execute by the authorities concerned.
I have relied on the judgment of Sanjay Dutt case, if your lordship remember, that is a judgment where the arms and ammunitions that has been interpreted. That judgment, in fact, that was also placed before my lords in the last. That judgment and regarding interpretation also I am giving. I have also relied on Panda Infra and that recent judgment.
When the
which my lord
interpretation
placed in
leads
reference,
to-
I have not gone through that.
No, that's a. Yeah.
Of course,
Mr. Tripathi argues, in one Miss Aishwarya Das argues. So,
12.6.
you know very well.
Adding cell blocking and something, but that is.
No, that is, I understand.
You
So far as-
first block them, taking away their right to participate. Thereafter, after 6 months, you blacklist them. So in effect, blocking the portal itself is
It's a debarment. It's a kind of a debarment.
Yes. Here,
is it not civil death? As
Here,
Honorable
my
Supreme Court has pointed the
the
board.
extensions were granted by the government, considering his application.
Oh, whatever be the reason, sir, you were successful in the Supreme Court in getting that order set aside.
No, but that is for the court's direction. Apart from the honorable
That
court's
is-
direction, even
I'm
the-
asking, that is what I'm saying, that you were so. I can't use the word. So you have done it. No problem. Now the question of how many, what is the total debarment period?
It was 6 years.
6 years.
So then if the tender invited experience of 3 years. If you exceed below the experience, you will not get 3 years, then it will be lifetime development. When all tenders, they are looking at the last 3 years
Clause
experience.
2(1)
So this
and 121 of the tender document was very much clear that in case you don't complete, it has to be as per the OPWD code. So
Yes.
what he is trying to argue is to rewrite the contract. Because
Sir, what he
cannot
says
take
is
the plea.
this is another aspect. If you debarred him for 6 years, and in every tender, the 3-year experience is mandatory under the OPWD.
The
Code.
tender condition, general terms of tender.
That is what is there. So it is mandatory there. Then he will never in future be entitled to participate.
In one of the cases, we have reduced it to 3 years.
No, even.
No, we have another
The
bench.
period of this-
I have read somewhere. That,
After term, we have reduced it. After term, we have reduced it.
after that.
It was for lifetime.
Correct. Right.
That is. But here is the
This
case.
can't be done. Oh, he has not completed. That means there may be multiple factors that may come. So you impose the penalty, give him debarment, something so that he will be, but not in this way.
Non-completion cannot be debarment. Non-completion only penalty. Debarment will two things. Substandard work.
Sir, this is included as the ground for debarment.
So this
Not achieving the milestone and
second part is not milled in
Not
either social
milled.
notice or in.
yes, give it to me. Yes. No, I will not. Give it to me. Please. I dictate today. Or tomorrow morning.
Note along with the judgment. They are already on record.
Give me some judgments are there. Yes, sir. Give it to me.
Orders to Orders to
So will come as for orders.
Item number 19.
There are two matters. Item number 18.
18 minor.
Oh, yes, yes. Huh?
Item 19.
This matter. That's levy of IGST and ocean freight bills. That was the nothing knows in case of Boeing Reynolds under Supreme Court. That is also because by virtue of two notifications, the government of India there's they have imposed IGST and ocean freight on which already without the petitioners across the country they discharge without the tax liability of IGST on the import value bills, which includes ocean freight. So because of multiple levy of tax on same ocean freight, once in course of import and again as service bills, treating the importer to be without the person liable under Supreme unconstitutional. The very levy unconstitutional. The two notifications the government issued bills, those are declared to be illegal or unconstitutional. So as a consequence, the taxes which are being paid, because the notifications was there 18 17.
So a refund you wanted.
8 million.
That
Now,
is rejected.
Refund is granted. Where pinches bills, because my difficulty is.
Is it a new one or old one?
My friend,
New one or old one? You say the shoe pinches, so I just wanted to know. It's a new one or old one?
yes, the new one seldom pinches.
No, new one, often,
Here also.
often, old one.
Often, yes.
Oh.
Yes, sir. What has happened? I have been paying bills all through because of the unauthorized collection because of the mandate notification. Now the notification having been declared unconstitutional because as a consequence bills under Article 265, because this has become without authority of law. So they have paid me the money without interest bills. In the meantime, what I am submitting bills, the judgments have come. After filing the petition, very recently, Honorable Bombay High Court in October 2025 has decided that as a consequence of the Honorable Supreme direction declaring the bills legally unconstitutional, the petitioners, those who have paid tax, pursuant notifications, are not only entitled to interest, refund as well interest bills. And vividly, they have dealt, Honorable Bombay High Court dealt with bills. In my case, in the counter which they have filed, there's two things they have said. One thing, they said that, and Bombay High Court again said, section 54, 56, which are the provisions for application of refund and consequence of that, those are not applicable. So this is different situation altogether. This is not a case because I have paid something and post application I am entitled. This is a case where every payment, every 1 rupee which is paid belongs. Pursuant to improve notification are going to decline on. So therefore here the money retained by the state over the period of years belongs and utilized and therefore not only belongs government is liable to pay belongs, they are also liable to interest belongs. Here a new novel idea is there in paragraph 70 counter I find today. The novel idea of the department they have contended that but they say the money which you have paid, government has not injured your money. Kindly remark one thing. Because the tax which you have paid, those are all input credit bills, those stand credited to the credit ledger, and the petitioner is entitled to use the money from out of credit ledger to discharge tax liability. But therefore, the department, whenever bills they consider by application of refund bills, they examine vividly to find out whether the money so paid pursuant to the notifications are actually utilized by me or this is lying in the credit ledger to my deprivation. And they found the money is lying. Why? Because the reason is twofold. Firstly, the non-utilization is very because of the statute restriction itself under Rule 89 bills. Because of inverted rate structure bills, what is inverted rate structure? My lords, if the rate of tax which I have paid is more and the output tax which I have to discharge is less or zero, then there will be accumulation of tax all around. So here I am in a position I cannot utilize my money. The tax which I have paid pursuant to the government notification, those are there with the government bills. I cannot utilize because the inverted structure I cannot, and those are lying. After verification, thorough verification of my application, they gave me 44 crores. 44 crores was lying At their instance, because of the notification, I have made payment and those are.
Is not actually parted with the money, but they actually lifted that particular statutory restrictions.
Correct.
And then it is open for you to utilize that.
Utilize. Now, because it cannot be utilized and money was collected by virtue of the statute notification.
Not collected.
So they refunded.
It was not the actual refund or the
No,
only
they
the
refunded. They refunded because
they accepted.
yes, money was lying with them.
Oh, that is what you wanted an interest on that amount.
Exactly, that's the only point.
So that money was kept with you, not with him. Is not the input credit, the input tax credit. That's on the.
So what I am submitting is I am giving copy of the judgment to my friend. Let him examine that. But can
What examine?
I am giving to your lordship.
No, this judgment is of a Bombay High Court. I have seen that.
And two more judgments to Gujarat also. That one is 2022 and 123.
Don't you have a 0 kilometer judgment? Yes. Don't you have?
Sorry, my lord, sir. Your lordship, lord.
No.
What is it?
Very good. No, if anything, they'll say yeah. But it's all clear in the nothing to
Section 54(7).
What is the rate of interest?
rate of interest, Honorable Bombay High Court said 6%. Sorry, not 6%. That is claim of refund along with interest and exactly rate of interest, not to Gujarat High Court said 6%, but Bombay High Court said you give that amount. Gujarat High Court said statutory interest 6%, but Bombay High Court said the amount of claim of refund along with interest 2 crores amount that was granted to be refunded along with interest, but the rate of interest was specified. Section 56 speaks of 6%. 6%, right?
That is 54/7. 54/7. The proper official. Madam, sir. Yes. The proper officer shall issue the order under section 5 within 60 days from the date of receipt of application complete in all respects. Now, my lords, come to 54/14. 14/2. Relevant date means 54/14/2. Relevant date means
No, I did not get it. I may be wrong.
GST.
What you are reading?
Court ruled while you
It does not have any subsection or restriction. Because
14/2D.
Only 14 is there. There is no two-way. Neither one, nor two, nor two-way. The explanation is what do you want to give? Definition of?
Explanation 2B.
My friend says explanation 1 and 2
I understand.
at the end.
2D. In case where the tax becomes refundable as a consequence of judgment, decree, order, or direction of the appellate authority, appellate tribunal, or any court, the date of communication of such judgment, decree, order, or direction. So after that order from this High Court, they have filed their return application and we have paid within 60 days. Sir,
Where is
this
the?
is Article 265. Assessment order being challenged and
Refund is.
Sir, it is, and wherever assessment order gets finality, if the assessment order is shut down or set aside or quashed, in that context, whatever tax are paid, that will be refunded on his application. So this is not well, directly. This is Article 265. Honorable Bombay High Court has made it very clear.
Also, interest restriction, there is a restriction when the refund is on the basis of the order of the assessing officer or the appellate authority. And the refund being on the basis of an order of the court. But how can you take advantage of those provisions? It is more on an equitable principles than this statutory.
The moment the minerals case came out, immediately you should have promoter refunded because you cannot withhold that money because Article 265. We have already paid within the.
No, sir, you were waiting for their application to be filed and then you proceeded.
As per order. 265 says you, without authority of law, you cannot hold the money. You held the money without authority of law. The moment my criminals highlights, you should have no motor refunded. This is not for application to be filed by the.
And your satisfaction is not the CD4 norm. As you have shown. Satisfaction, if it is satisfied. What is the satisfaction? It's a mandamus which is included. It's a declaration of law.
Constitutionally.
How much you will pay?
The description is there. I will concur in this matter of.
From the day of the deposit or from the day of the judgment of the Supreme?
Judgment of.
Once in the 265, it goes back to the date of payment. It goes to date of back to date of payment.
Doctrine of relation back is not uniform or sacrosanct. Sometimes the court may restrict. You are taking shelter under the doctrine of relation back.
Now, what is the Bombay High Court?
On the Bombay Court says the same thing.
from date of payment, entire payment belongs, entire payment which has been made belongs, on that direction was made for grant of refund with interest. Whatever claim was made, that was allowed. Only rate of interest is not clear. Not clear. But
some amount calculated by the
no, not some. He has calculated while making his claim belongs, and that was allowed. We do not know exactly.
Here, I think standing counsel did not oppose. They have agreed.
But Honorable Court in any case in Gujarat, Honorable Gujarat High Court is very lenient, 6%. Your Lordship directed 9%.
No, I have followed the Honorable Supreme Court.
No, I understand, but it's only 6% because.
Oh, that is it.
Statute says 6%.
I am still more wiser.
Again.
I am more wiser.
But your Lordship have all. Honorable Bombay High Court has referred to Virat's Mauka plan.
Why don't you concede to 3%? We will
I leave entirely to your Lordship Virat. Any person just stepping into the shoes of the client Virat, if I think of a moment, losing 44 crores Virat for 4 years, gradually by accumulation process, it's a capital loss Virat. It's difficult to carry on business for any entrepreneur.
This is Government of India undertaking.
Oh, if you sit, then I will say that what they do.
No, I am not saying anything to Lordship. Your Lordship kindly, pragmatically, plus, with her approach that should best serve the interest of the party.
Why are you pressing for this? This is Government of India undertaking.
Paradip first.
No.
No.
The fertilizer department is
Paradip
controlling
first.
this.
No, Paradip first is not Government of India.
You are a public.
It's a public limited company.
Limited customer. So we are gone into.
It was under BFL. Your Lordship was also hearing one matter some months
It has
before.
gone into the BIFR.
Was now that stage over. Now that stage over.
Rehabilitation scheme.
Now it is having some profit. Let me.
That was in the year 2014.
Long back. Yes. That stage is over.
And that was not because of this 44 crores. So you say you have to do it. You have to pay.
After all, I have to take it whether this order has been challenged before.
No.
How
can we take instruction? After apex court judgment only I am before this order. How can I again challenge?
No. Gujarat judgment.
No, not challenge. My associate says he has inquired, he is not challenging. This can be, it takes some minutes only to verify. But he has verified, not challenged.
So what to do? These are 2022 orders.
Yes, ma'am.
Yes.
Item number 20.
My lord, I beg apologies for appearing through VC, my lords. On behalf of Learned,
Item 20, sir.
my lord, on behalf of Learned Reasia, my lord, I'm humbly pray for adjournment, man. Is out of station due to some bereavement, man.
Bereavement in the family. One thing. Next week.
21. 21.
Here in this case, I am filing case Bhinama. Yes, this Bhinama from the, what is this? Yes, Okalatama. What you said? The previous council, what is Okalatama? The previous council had given consent, so I am appearing on behalf of the petitioner, with some filing some additional document with additional affidavit. Mr. Das. In the hearing, everything. Yes, what you have to say, these are the subsequent event of the 10th of December. The mining officer has already indicated that he has paid all the permissions and you can issue a consent to operate.
Millet, I will take instruction. But the millet prayer, the prayer is a twofold millet. First is to grant the blasting permission to the
True, their grievance is that the you have unreasonably withhold the blasting. What was there? Now, during the pendency of the writ petition, he in the additional affidavit, you come to the last document at page 20, which is of a recent origin, 10th of December. 10th of December. Have you got that?
Yes,
please read this second paragraph, third paragraph, and fourth paragraph. Is your mining officer who is saying? Are you reading a letter dated 10th December?
Yes, I'm on
Please come to this. The second paragraph says the lessee has already deposited all pending dues, royalty, and other applicable charges for the financial year 25-26 in order to update the query smoothly under Corner District. The WPC number is pending before the Honorable Orissa Court filed by the petitioner himself regarding blasting permission. There are no issues concerning the grant of consent to operate. So you say that now there is no issue. You can grant a consent. And this consent will be granted by the regional officer SPC board. So
on this document, I will take instruction because counter is something different. Counter filed by the mining officer is something different. Now I am coming.
I do not know, but this is the stand.
10-12.
12.
10, counter was not been filed earlier. So
Therefore, my lord, I need to take instruction.
at that point of time, there was dues. He said that I have deposited all the amount 4 crores.
My lord, 40 lakhs I have
40 lakhs he deposited the entire amount.
Just my lord, just I'm receiving the copy. I will take instruction on
That we have also received just now.
In any short date, my lord, I will take open instruction today. Why I am submitting that, my lord, I will take instruction. My lord, the counter is filed by some person. Now the incumbency has been changed. And this is signed by DDM in charge for that. My lord, I will take instruction.
What? Signed by?
DDM in charge.
No, he is a mining officer come.
DDM in charge.
DDM
IC in charge.
What?
That's why I want to take instruction.
Deputy Director Mines.
He's a different person now. And counter was filed by one Dilip Kumar Sahu. He was the deputy director of mines at that time, my lord. That is.
Contributed by Deputy. You have to something, just examine that.
Yes, more. Yes.
Parichhala.
Borne Patrick.
Parichhala is the nearest. My lord, so that is that is just not near Borne. Not near Borne.
Begunia was.
Begunia, my lord, that is yes. Begunia is
See, Borne is to father self-put.
no, my lord. Begunia is going to different block, different. That is away 45 Borne. Away from the town, my lord, that town. Far away. Borne is not encircled by. DOP has given by that techno. Aspongo is that backside for. Begunia is Noyagar.
That's not a down of the
That is a total.
area, around 100 kilometers radius.
DOP has also given this one.
100 kilometers radius. Yes.
However, we are taking a particular case of a blasting permission. We cannot overlook the recent incident that has happened. I think 3 days before, when 2 persons they died at the time of blasting.
That's why.
What steps have been taken by the government to ensure the safety and the security of those persons? Is there any
standard norms or the standard operating procedure or any rules or the regulations or a guidelines being issued that what it has to be done?
Human life as well as
The life of the many people.
inside
Mr. Roth, the senior, we again wanted to put you in trouble. Because if this matter has come up, you're thinking like this, that why not, we take this opportunity and then to say if the government has not formed any kind of a
Policy or
the
not.
standard operating procedure, the rules or regulations. What should step in because of the realities?
See, the question of blasting is involved in case of blackstone mining.
Wherever the blasting
Takes place for
permission
the
is
purpose of
required,
mining.
then in that case there should be some safety measures. There should be some check and balance. There should be some
Yes.
norm.
So let us first do one thing. Let us first examine what are the check and measures provided on the rules and what are the check and measures already available.
Any rules I do not find.
They are.
It's not enough.
There is the Orissa manual rules that says that there is a distance factor that's there. Within habitation, what distance, probably some distance is there have the
No, this is only for the purpose of the mining
yes,
activities.
mining activity.
But what about blasting?
Blasting-
Talking about a blasting is different. One can do a mining with some kind of a manually without using any.
Yes, by putting a
dynamite,
hammer and other things, right.
whatever. So without using anything.
Blasting should be strictly adhered to.
Absolutely, this is what we are.
That should be strictly adhered. Your Lordship, give me a chance, I'll examine that part.
Please examine that part.
Yes.
And we take this case.
Yes.
Because he is asking for blasting permission.
No, brother, otherwise, my lord, when public interest comes, I am there always, I can't
you
compromise.
should also visit Tapam.
Dangerous situation.
Have you seen that?
Yes, I have seen
I
that.
visited.
I once or twice I have gone there.
I think 6 to 7 years ago I have visited that place.
Lordship will be surprised.
Entire area.
600, 700 feet depth. 600, 700 feet depth below the ground.
The water logging?
Yes, huge, tons of waters.
So creating an artificial antelope.
Yes, that's there. And people die there also by falling inside.
That's why I said 6 to 7 years ago.
Yes, so a news item came.
Now I
Some
think
boy,
it is
one boy, yes, boy and girl, they had gone to move.